terminated my dealership agreement a while back. And they are now intended to take over my lot. Today, my lot. Okay, two. Grateful. Make this motion. The person of the other side explanation, I can.
I hope you have told the other side.
Yes, sir.
Mr. M.K. Chaudhary, I think.
Already concept.
Yeah.
I beg to mention item number 43 of the supplementary list.
43.
You know that given 2 weeks time will be allowed to file our affidavit according the IA.
43.
It's covered for the person.
Yes, what about 43?
My lord, I am appearing for the applicant, my lord. My lord, the date may fix, my lord, after 10 days.
Okay, you want to adjourn the matter
Yes, my lord, to file our affidavit in the IA.
in the IA?
Stay vacating, my lord.
Okay, right.
After 10 days, my lord,
Mr. M. Smith, learned counsel for the petitioner is granted
10 days time.
10 days time to file written objection to the IA. List the matter.
That way.
Hmm?
And it may be 40.
14.
30 or
14.
my interim order.
Interim
No,
order
but
to
that is not necessary, my lord, because they file a petition for vacating.
No, my lord, because the order was
That,
still the
that
next
my
day.
lord, part, my lord.
interim order to continue till the next. How does it matter?
Yeah, please, lordship.
Acha, Mr. Saiwala, one thing. That matter you have seen the order
No, I
yesterday.
didn't get it, man.
Oh. Okay.
I beg to mention for listing an IA in connection with item number 41, today's daily list. Finally, the matter may be called for
Item 41.
item 41. I have filed an IA yesterday.
Okay.
All right.
Has it been numbered?
Item number 41.
Has it been numbered? The IA, has it been
Yes,
numbered?
yes.
What is the number?
Filing number 5366.
No, what is the IA number?
I have not been numbered. Yesterday I have filed, Your Honor,
It has to be numbered. What is the issue about?
for the implement of the party.
Okay. Let me check. If possible, I'll
right.
give you a thing. If it has been numbered, it will come. And what is the urgency in treatment?
Because,
Contempt
one of the parties has been transferred.
on Tuesday? Let's say on Tuesday.
Under the contempt case is listed in today. In the same
We'll list the contempt also on Tuesday.
Tuesday.
Right, in item 41. Mr. What is your
A.
name?
Banerjee,
A. Banerjee appearing on behalf of,
petition.
your name is not here.
Yes, no.
In the Wakalatnama, it's not there probably.
Yes, earlier my junior,
Huh?
earlier my engaged counsel junior was appeared before, and I have filed today,
Have you filed Wakalatnama?
not on behalf of.
He has not been petitioner. That is why, please make your submissions on behalf of the council who is a recorded council.
On behalf of N Sarkar.
Mr. Spencer, on behalf of Mr. A. Sarkar, on the council for the petitioner, submits that. The treatment application submitted by the petitioner is not on record. The filing number being, has not been listed. The filing number being
5366/25.
5366/2025. List this matter along with the application for implement on Tuesday. Okay.
Yes, but it's pending matter, my lord, regarding not of bill matter. 24 matter may be listed for admission next week, my lord, admitted amount. Any day.
Pending matter, seat.
24.
Huh?
2024.
There's no hurry. You go to the registry. No hurry. Contractual dues, no hurry.
Madam, I beg to mention, listed one case, on 8th of EMB.
Why? What is the matter about?
My lord, matter is, the petitioner was, allotted one, plot of land. That plot of land, possessed by other person.
Huh?
The petitioner was allotted a plot of land for business purpose. That's
For business purpose.
for
Then
business purpose. The other party are encroached that property.
has Encroach.
Encroach that property.
Is that a bench four matter?
Yes, Ben.
Encroachment of land,
Yes.
bench five,
Five.
bench five matter. Not a bench four matter.
Sorry, wait. Did you mention item number 24?
Yes,
I have instructions to withdraw this.
okay, item 24. Ah. Okay. Yes, for that low rates justification, yes. Mr.
H. Agarwal.
A.
H. Agarwal.
H. Agarwal, that is counsel for the petitioner. Says that he may be allowed to withdraw the writ petition as he has been given instructions to withdraw the same. Who appears for the other side?
What are you?
The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn.
मैं please करूँ. Also, I beg to mention item number 21.
21 years.
21, I'm making this mention on behalf of, I'm making a mention on behalf of Mr. S. Tamaria, my lord. I'm not the recorded counsel, my lord. My lord, what has happened, my lord? It is petition, my lord. The subject matter is a non-payment of the contractual due to.
Correct.
According to the instruction of the water resource department, they have paid a substantial amount. So there was a direction before by this honorable court, it was to be disposed of, my lord. And what has happened, my lord? We have tried to contact our client, my lord, but he has not responded to our queries, my lord.
Probably he's taking the money, doesn't want to give you your share.
That may be, my lord. My lord will just give us short accommodation, my lord. We'll just
When, next week?
next week, my lord.
Okay. Right, Mr.
A.N. Sharma, my lord.
A. Sharma appearing on behalf of
Mr. S. Tamaria.
Mr. S. Tamaria submit that the stand of the state respondents is that a substantial amount of the contractual dues has been paid to the petitioner. The petitioner's counsels have, however, not been able to communicate with the client with regard to the present case. He accordingly prays for time to do the same. List the matter on Tuesday,
I'm deeply aware.
6.
Nothing, Your Lordship. I beg to mention item number 20.
Yes.
Lordship, I'm appearing on behalf of Mr. A. Kalita. Lordship, today he has some personal difficulty.
Who is for the petitioner?
Chair for the petition.
Okay. Adjournment prayer has been made on behalf of Mr.
A. Kalita.
A. Kalita, learned counsel for the Industries and Commerce Department. The same not being objected by Miss
R. Jupli.
R.
Jupli.
Julie. Jugli. Learned counsel for the petitioner. The matter adjourned for
Lordship, 2 weeks.
2 weeks.
Obliged.
This is a 2017 matter, Mr. Counsel. You're for the 2017 matter.
Was written for the other side. Sorry.
Okay.
Obliged. Please, Your Lordship. Lordship, I beg to mention item number 2 for adjournment for 4 weeks, Lordship. We have taken consent from other side.
That is all right, but what is the fate of your attempts to compromise? Anything happening? Yes, okay, right. Adjournment prayer has been made by Mr.
A.K. Hajan. I'm appearing on behalf of D. Ghosh, Lordship.
Has been made on behalf of Mr. D. Ghosh.
Yes, Lordship.
Ms. D. Ghosh, learned counsel for the petition. On the ground that there's an out of court settlement being attempted. This is the matter after
4 weeks, Lordship.
4 weeks. You see, you have filed the case and you are attempting a compromise. Is this a tactic, pressure tactic? Right. No further adjournment shall be provided on the next day, inasmuch as the orders show that the petitioner has adjourned the matter, has been adjourning the matter, thereby giving rise to an inference that the filing of this case is only an attempt to pressure the respondents to enter into out-of-court settlement. You tell your senior to come and explain.
Obliged.
Your Lordship, I beg to mention item number 23. Lordship, my
23.
senior is not present with
Who is not present?
my senior Lordship and K. Chaudhary.
Okay, right.
So adjourn for the day also. I'm S.N. Ahmed Lordship on behalf of M.K. Chaudhary.
Where is he? Where is Mr. Chaudhary?
Lordship he has not come.
He's not come today.
Yes, some personnel different.
We listed on Monday.
Okay.
Right, adjournment prayer has been made on behalf of Mr. M.H. Chowdhury. Full stop. A perusal of the pleading shows that the petitioner has made a prayer for non-payment, has made a prayer for payment of contractual dues. However, the stand of the respondents is that no work orders have been issued to the petitioner. Full stop. The petitioner will thus have to explain as to how he can make a claim for contractual dues in the absence of any written orders issued by, in the absence of any written work orders. This is the matter on Monday. Tell him to come. No adjournment shall be given on the said day.
Supposed to file a reply of suit.
Hold to file the file with. Madam, come to para 6 of your affidavit. Yes, what to do with this para 6? Is this a outstanding amount?
A department has no record that whether he has completed the work or not, Lordship.
Well, madam, if you've got no record, please go and verify. You see, it's a issue of verification to be done by you. If you want the petitioner's verification, he'll give it to you. Within 2 seconds, he'll give it to you. He'll write a letter saying that it's verified. You want his verification or you want your own verification? Huh? With regard to that, so there are out here, one is with regard to Hailakandi and one is with regard to that Kaichera. Correct?
Yes,
Kaichera, there is nothing,
nothing.
so that goes. But for this Hailakandi,
Oh.
you have not denied. The only stand you have taken is that there is nothing to show that it has been completed.
Yes,
Correct?
yes.
So you do an exercise.
Okay, Lord.
You tell the executive engineer
Will
to
do.
verify whether it is completed. If it is completed and there's outstanding amount to pay, you pay. What remains? Right. No one appears for the petition on call. Ms. J. Gogoi appears for whom?
Water resources.
Appears for the respondent's number.
All responsible.
Huh?
All responsible.
Appears for all the respondents. The petitioner's case is that he had been given various contract work by the respondent for protection from river erosion of Hailakandi town. in relation to the river Daleshwari. It's not Daleshwari, it's Wari, I think. Daleshwari. Daleshwari, huh? Because this Daleshwari comes from Mizoram, the river. It's not Daleshwari there, it's a different river. And in respect of, and for protection from river erosion at Kaichera on the right bank of the river Katakhal and Daleshwari river. The petitioner's case is that he has not been paid his contractual dues for the various works that have been allotted to him, which is reflected in para 3 and 4 of the writ petition. Next para. The affidavit of the respondent number 2, that is the Chief Engineer, Water Resource Department, is to the effect that the petitioner has been allotted different work orders by the Executive Engineer, Hailakandi Water Resource Division. Which are as follows. Now, which is reflected in para 6 of the affidavit in a position, which is reproduced here and below as follows. Para 8. The paragraph 8 of the affidavit, the position filed by the respondent number 2, states that though the petitioner has stated that he had done another contract work, namely, in bold it is here, the office of the respondent number 4 could not give any confirmation that with regard to the said contract work, with regard to whether the said contract work had been done by the petitioner, as there was no documentary evidence like work order, technical sanction, bills, etc., that could be traced out by the office of the respondent number 4. On considering, next paragraph. The para 10 of the affidavit of position. No, para 9 and 10 of the affidavit of position filed by the respondents. Para 9, 10, and 11, of the affidavit of position filed by the respondent states as follows. Next paragraph. On considering the fact that the respondents have taken a stand that there is no completion certificate with regard to some of the contract works done by the petitioner, this court is of the view that the same can be verified by the respondents themselves. As such, with regard to those contract works which have been done by the petitioner, as per the records of the respondents, respondent number 4 should, respondent number 2 and 4 should ascertain whether the contract works have been completed by the petitioner. And if the same has been completed, the outstanding liabilities pertaining to the said completed contract works should be given to the petitioner. In respect of the contractual dues claimed by the petitioner, in respect of contract works where there is no record of work orders. Etc. Comma. This court is of the view that the same cannot be the basis of making a claim for contractual duty. As the issue of whether any contract work had been issued to the petitioner would first have to be proved. In respect of, accordingly, in respect of those contract works where no work order is traceable in the records of the respondent number, in the records of the respondent, the petitioner may avail of, may approach the civil court for redressal of his grievance by adducing evidence to the effect that he had been issued work orders for a certain estimated amount and which he had completed with the knowledge and permission of the respondent. Next paragraph. With regard to those, no, next paragraph. In view of the legal state above, this writ petition is disposed of with a direction to the respondents to verify whether the work orders mentioned in para 6 of the affidavit in position have been completed by the petitioner. And if the same had been completed, the outstanding amount for the same should be paid to the petitioner. The entire exercise with regard to para 6 of with regard to the verification to be made, verification and payments to be made in respect of para 6 of the affidavit in opposition to be completed within a period of 4 months from the date of receipt of a copy of this order. The writ petition is accordingly disposed of.
In this matter, my lord, our affidavit is ready and sent for checking, my lord. Otherwise, not is admitted.
Admitted.
And my lord,
Oh, but the affidavit, let it affidavit.
let it,
Mr.
Fine.
G. Bokalia, learned counsel for the
government,
government advocate submits that the advocate, no, that the affidavit in the position has been sent for vetting, wherein the amount claimed by the petitioner has been admitted.
well, affidavit from the revenue department is required because deputy commissioner sought fund from the revenue department.
Fund is a different thing. We just want to know whether the amount is a genuine claim or not, that's why. You're for which department? Mr. G. Bokalia,
I am government, my lord, phone number, district commissioner, my lord.
for the district commissioner. Mr.
Phone number 6.
S. Data for the revenue department submits that. What, are you filing anything? Submits that he will obtain instructions as to why funds are not being provided to the district commissioner's office for payment of the dues of the petition. This is the matter. When?
After 2 weeks.
After 3.
Give a date after 2 weeks. End of the month.
In item number 4, my lord, we are awaiting inspection, my lord.
Okay.
Similar matter, my lord. I am.
See, what do you mean civil order? It cannot be civil order. In 1 year.
Contractual bill, my lord.
Okay, right, Mr. Mr. J. Payan submits that contractual dues, huh? He's the petitioner, no? Mr. J. Payan submits that contractual dues has not been paid. Mr. G. Bokalia submits that he has received no instruction.
I'm only applying for F1 note 6.
Forget that, just say that issue notice returnable in 4 weeks. Mr. G. Bokalia accepts notice from behalf of point number 6, while Mr. S. Data appears for point number 5. Ms. J. Gogoi appears for 120. This is a matter of the 4 weeks to enable the respondents to file their affidavit. Yes. Again, contractual dues. Give me.
Matter of non-payment of bill regarding higher bill. Item number 5, respondent order to file
We
affidavit,
have
my
file
lord.
affidavit.
To what effect?
The amount is admitted, my lord.
Step will be taken to the credit of the account of the bank, account of the petitioner, but till today we have not received any amount, my lord. Para 2 of the affidavit, case number 21.
So this is admitted.
Admitted.
Heard, Mr.
G the car.
G. Dekha, counsel for the petition. Also heard Mr. G. Bokaliel for the respondent. The petitioner has paid for payment of his vehicle hire charges amounting to rupees 10,54,302. Mr. G. Bokaliel appearing for the respondent submits that the amount claimed by the petitioner is an admitted amount and that financial sanction had been accorded by the sanctioning authority for payment of the petitioner's due. However, the financial sanction had lapsed and accordingly, steps are being taken for revalidating the financial sanction given earlier. To stop, Ms. Barrack. I have heard the learned counsel for the party. The stand of the counsels for the parties make it clear that the respondents are liable to pay to the petitioner the admitted amount of rupees 10,54,03. 302. Para 2 of the affidavit in a position filed by the respondent number 3 is reproduced herein below as follows. Page 21. It is there. Next, in view of the admission of the dues of the petitioner by the respondents, the respondents are directed to revalidate the financial sanction for payment of the admitted amount of rupees 1054,302 to the petitioner. The entire process for revalidating the financial sanction and payment of the admitted amount should be completed within a period of 2 months. 3 months. 3 months from the date of receipt of a certified copy of the file. The writ petitions accordingly disposed of. Now, what about 6?
Item number 6, they have not filed any affidavit.
No, my lord, in
Same
this matter,
petitioner,
my lord, in this matter, our letter is ready, but extra copy not served.
Extra copy is not served?
Not served yet.
What do you mean extra copy is not? Extra copy or writ petition?
Read petition.
they will serve.
Heard, Mr.
G the car.
G. Dekha,
Yes.
learned counsel for the petitioner, who submits that the petitioner has not been given his vehicle hire charges amounting to rupees
12,87,260.
12, comma
87,
260. Issue notice returnable in 4 weeks. Mr. B. G. Bokaliel accept notice on behalf of all the respondents.
All right.
List the matter after 4 weeks to enable the respondents to file their affidavit. Extra copies of the writ petition be provided during the course of the day to Mr. G. Bokaliel.
Obligation.
And no, this court has become basically a
Contract, not.
recovery, court for recovery of money, that's all.
Yes, yes.
Yes, what has happened out there?
In this matter, we have received instruction or we will file affidavit, madam.
Admitted, not admitted, what?
It is admitted, madam.
Affidavit come.
The amount is used, madam, 1,21 lakh.
1 crore, how much?
Oh, no, madam, 13 lakhs.
Correct, that's what I was thinking.
One
Is-
crore is the total balance amount, so also we'll file affidavit.
You have admitted 13 lakhs? You know. You have only talked about the entire scheme, I think, or
Yes.
project.
The entire scheme is indicated here also.
Is there anything specific about the petitioner? Have you admitted the petitioner's amount?
That amount is admitted 13 lakhs.
Admitted? Oh,
The higher. The claim was a 40.
1344,264.
Some discrepancies is there also.
Okay, right. Mr. J. Paya, land counsel for the petitioner submits that the contractual dues of the petitioner amounting to rupees 13,44,264 has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokalian accepts notice on behalf of
District Commission.
That one was 6.
point number 6. While Ms. J. Gogoi accepts notice on behalf of 1, 2, 3. Finance, who for finance? Mr. M. Buya accepts notice on behalf of fund number 4. What about revenue?
5.
While Mr. F. Datta accepts notice on behalf of fund number 5. Mr. G. Bokalian submits that parawise comments have been received and he will be filing affidavit within
2 weeks.
2 weeks. This is a matter of 2 weeks. Yeah, make it 2 weeks. Issue notice returnable in 2 weeks.
18-9. Same issue, same parties are same.
Parties same everything. And you have received parawise comments here also.
Yes, our affidavit.
It's the same order. 9 and 10 was the same order.
8 and 9.
8 and 9, same order. You have not filed affidavit.
No, our affidavit is sent for vetting.
Okay, so, okay. 2 weeks, same thing, same order. Exactly same.
27. But
Huh?
The particular office.
This is also non-payment of the outstanding bills.
Where is your name? Where is your name in the high power committee report? Where is your name?
No, man, in the high power committee's report, there is no name has been given.
Then how do we know that
Specifically,
Huh?
earlier, this petitioner has already approached before this honorable court.
may have been approached? You see, you are making a claim for payment on the basis of the report. In the report, where is your name?
But in the report, none of the,
No person's name is there.
no. Simply what had happened, well, here in this case, the 2 reports has been submitted. One report by the Law Reform Commissioner, and that report was against the petitioners, that the suppliers. Then subsequently, another inquiry has been conducted by the CM Vigilance Cell. CM Vigilance Cell has given in favor of the petitioner that supply has been paid.
Where? Show me.
But can you see? That has been clearly mentioned in the final report, page 88. This is the inquiry report.
Show me the relevant portion. Don't show me the irrelevant portion.
But the findings and the suggestions, page 93. The inquiry officer of CM Vigilance quoted in his report that Sri Ahmed Hussain IAS Commissioner and Law Enforcement Division was contacted to record his statement, but he refused to give the statement and asked for official letter for regarding his statement. So a letter was sent to him with a request to give his statement. On receipt of letter, he gave his statement in writing. As for the statement of the Sri Ahmed Sri so-and-so, the inquiry conducted by him in respect of flood of 2016-17 was based on documents provided to him and the statement made by the persons who were summoned before the inquiry. As per his inquiry report, only the government officials were summoned. He had neither visited the flood affected areas nor recorded the statement of the flood. On the basis of the above fact, it is stabilized that during 2016-17, there was a devastating flood in Satsalva, Vankaso district. Rescue and relief operations were carried out. As per the standard norms by the district authority.
So how does this prove that you are one of the contractors?
The list of the well, can you see in the earlier occasion we have approached in page 79.
No, you see, the fact of there being a flood is not disputed now, okay? But the question whether you are one of those contractors who had done work,
Well, can you see,
that has to be proved.
well, page 27. That is the order given by the Deputy Commissioner for supply of the materials. Well, page 27.
Yes.
Page 27, this is the supply order. The Mukesh Kumar Agarwala. The supply of the wheat or bread, you are asked to supply the wheat brand so and so approved rate of the Deputy Secretary Manchester. Arshimadi to the
Wheat brand for what? For what? For what purpose are you going to do this?
But immediately as GR materials, sir, the
Huh?
government relief.
What is GR?
Government relief materials. Well.
Government relief material.
Yes.
And this is going to be used for what? For strengthening the embankments.
No, but yes, well, for the flood devastation.
Huh?
So for the flood, my lord. Flood was occurred during the period 16.
So this wheat brand is going to be used for what? For eating or for
For eating.
Huh?
For eating.
For eating.
Yes. And then, my lord, another is also there. So many orders, Indian orders is there. On page 31 also.
How do you prove this? There is nothing which admits. And this is of 2016. We have filed this writ petition in 25.
Yes, earlier, my lord, another petition has been filed. My lord, can you see page 79?
Yes.
Page 79, the 2017, the petition was filed.
On the same case, this is their second round.
Second round.
So this writ petition has been filed by you earlier
Yes,
on the same issue.
same issue.
Then why now this decision order was passed in 21.
Yes.
Why didn't you file a contempt?
No, my lord, what had happened in this case, at that point of time, the inquiry was not completed. That's why court has given the direction. As and when the inquiry, well, kindly see the last part, my lord. The relevant portion.
Yeah.
In view of the opposite direction, the resolution is also disposed of with the direction to petitioner to approach the Commissioner, Revenue Disaster Management Department, and thereafter to examine the claim of the petitioner. And pass the approval indicating the amount payable, so and so, and access there, so and so. And at that point of time, my lord, the Commissioner Secretary,
That is not reflected here. That is not reflected here in this order. Don't try to put something that is not here in this order.
and thereafter, my lord, the inquiry committee has been constituted.
Your name is
And
nowhere
other
reflected.
similar, my name is also there, my lord. Let my lord notify
Show me.
me.
Where is your name? Show me.
But in the Indian orders itself reflected, that order has been given by the Deputy Commissioner to supply the GR materials, my lord.
How can you file one writ petition after the other on the same issue?
Because the after filing of the inquiry report, my lord, in the similar nature,
So
some other,
is it so according to this, they have not complied with the order?
no, well, thereafter, these two inquiry reports has come up.
Look, Mr. Counsel, this order has directed that you should approach the authorities and they should thereafter take a decision.
Yes.
Now, have they done it or not?
My lord?
Have they done it?
No, well,
Have they complied with this order?
they have passed a common speaking order, my lord.
Yes, saying what?
This speaking order, my lord, subsequently I have got it. In this speaking order,
Show me the speaking order.
in another similarly situated person's case, my lord.
Look, I'm not on this. Don't try to confuse the issue. The issue is this. There is an order passed in your case, in the earlier writ petition. Has it been complied with?
Not no.
Then
But the subsequent development has taken place, my lord. This is regarding the final report.
In the subsequent development, your name is not there.
But in the state inquiry report, none of.
Look, why you see, your case has been
Well, I
decided
may be
here.
allowed 2 weeks time, my lord. I will bring on record some documents, my lord, by which I will show that I was one of the part of that order.
Right. Mister
Use the RS
Huh?
number. With the
R. Islam,
comparative-
learned counsel for the petitioner. Submits that the petitioner has not been paid his contractual dues for supply of wheat bran,
Well, others materials also.
wheat bran and other materials
Yes.
in the year 2016, when a huge flood had devastated some areas within a sum. Due to non-payment of his dues, the petitioner had filed WPC 7900 of 2017, which had been disposed of by order dated 21/1/2021 with the following direction. Page 81, the second last paragraph, in view of the prospect, okay? Next paragraph. The petitioner has now approached this court without taking a stand as to whether the order passed in the earlier writ petition had been complied with. He has now come to this court by stating that the petitioner should be given his contractual dues on the basis of the inquiry report made by the high powered committee, which has basically stated that, which has basically proved that a flood had occurred. In the South Salmara, Mankachar district. However, the petitioner's name is not in the report made by the high powered committee. So as to prove that the petitioner's contractual dues are an admitted amount. And as to whether the petitioner is entitled to payment of his contractual dues pursuant to the high powered committee inquiry report. Next, on the prayer of the petitioner's counsel, this is the matter of 2 weeks.
After 2 weeks.
Make it 3 weeks, after 3 weeks.
Lordship, but last official, the Chennai government advocate was directed to take instructions in this matter, madam.
My lord, in this matter, they have no, sir, extra copy of rate petition.
We will serve, madam. We'll definitely serve, madam.
All right, very thing.
Is this your second round?
Yes, madam. Earlier Lordship, it was disposed of with the direction to verify. Thereafter, madam, we are regularly pursuing the matter. Lordship will find
So
from.
did they verify?
No, madam. No communication has been made. That is why we are before the Lordship, madam.
Then why didn't you file a contempt?
Madam, because they were assuring that they are taking steps in this behalf, madam. So, madam, we were hopeful that it will be done in a short period of time. Madam. That is
Now
the.
there's no point. You see, the problem is we cannot do if I dispose of in the same line as the earlier writ petition. Now,
So, madam, we will serve them the extra copy. That will be after 2 weeks, madam. In the meantime, they can also, madam, bring on records to stand up.
yes, Mr. Mukhaler, why you not just verify and find out whether he's liable to be paid? That's all.
Yes, madam.
What is the difficulty?
We will communicate.
You are not bothered with the orders of this court,
No, madam.
huh? No, you don't seem to be bothered with the orders of this court.
We have no information, my lord.
We'll ensure that that the officers have got information. We'll tell them to come. Let them come virtually, appear virtually.
Let them some extra copy, we will communicate, madam.
Probably they can.
Huh?
Some decision may be taken also. So, Lordship, may give 2 weeks time, or in the meantime, Lordship will come up with it. whether they have taken a position or not, that part you see.
No, you see, the second time coming here.
That is there also, I have also seen that. In a case, which time of in the.
And just prior to this matter also, the other case was there.
Probably they have taken position of the, that part, they have yet no.
No, you see, if, now even if I pass an order now, it's going to have the same fate as the earlier orders. And basically that means that they are least bothered with the orders of this court. If they are least bothered with the orders of this court, then we have got to find an alternative way of dealing with the officers. So that at least they, give some kind of respect, to the fact that there's a high court functioning.
I don't like it, which time of in the time to do that.
Please tell your officers to, to comply with the order.
The best of the earlier order of the, which time.
Otherwise, we also don't want to be, harsh. But if push comes to shove, we'll have no choice but to do. Right. Mr.
M.A. Chaudhary.
M.A. Chaudhary, Land Council for the petition. Submits that the petitioner is a registered vocational training provider in the e-procurement system for implementation of skill development initiative scheme. Based on modular employable skills under the Government of India. Though the petitioner has been given a certain amount of his bills, all his bills have not been paid. Till this. He submits that. In the earlier round of litigation, that is WPC 5611 of 2020, which had been disposed of by an order dated 2/9/21. The respondents were to cause a verification to be made and to pay the admitted amount to the petition. Three and a half years later, the petitioners have approached this court again on the same issue by this writ petition. On the ground that the direction passed in the earlier writ petition has not been complied with till date. The petitioner's counsel submits that the problem faced by the petitioner is that in terms of section 20 of the Contempt of Courts Act, the petitioner is unable to approach this court for initiating contempt proceedings against the petitioner. As such, she has approached this court again for again, Mr. On considering the circumstances under which the petitioner has approached this court again, it appears that the respondents are least bothered by the orders passed by this court. For whatever reasons known to them. Keeping the above in view, this court is of the prima facie view that no, forget that. Keeping the above in view, it is hoped that the respondents will consider the present case seriously. Accordingly, Mr. G. Bokalia, learned counsel for the
As per number 226.
2 to 6 shall obtain instruction with regard to this case. And obtain instructions as to why the directions passed by his court has not been complied with till date. He shall also obtain instructions as to the date by which the directions passed by this court shall be complied with. List the matter on when. After, we'll give you time because panchayat election is there also. But you come with some positive answers, okay?
Dixon, June to will come out with a positive.
Okay, second June. Come with some positive answers.
Extra copy maybe short.
Within the course of the day, man.
Lordship, regarding the instant cases, I've been told that we have received verbal instructions that the financial sanction is underway. The process regarding the payment is underway. We'll receive proper instructions regarding this by next week. And on the basis of that, we can file our affidavit.
Financial instructions are, or financial sanction is underway.
Yes, under-
So you have admitted the amount.
yes.
You pay then. What remains?
I think that it would be best if we have proper written instructions also, because we've just received verbal instructions. Proper written instructions
When can you get the written instructions?
by next week, Lord. Please, by next week, we can get.
Right. Has Mr. N.J. Khatane, Learned Counsel for the petition, who submit that the petitioner has not been paid his contractual dues amounting to rupees 19,98,080 for repairing and renovation of the office building of the additional Chief Medical and Health Officer bracket FW, that was Morigaon. Next para. Mr. M. Buyan,
Lord,
Learned Counsel for the Finance Department, appearing on behalf of Mr. B. Gogoi,
Lords.
Learned Counsel for the Finance Department, submits that that financial sanction has been sought for payment of the petitioner's dues from the Finance Department. He submits that the PWD.
Lordship, I'm appearing on behalf of the PWD department and it's not finance.
Okay, yeah, prefer. Okay, fine. It submits that the PWD is expecting approval of the Finance Department soon. He also submits that written instructions with regard to the fact that the PWD has sent the request for financial sanction to the Finance Department will be provided in the next week. List the matter on 6th.
Lordship, one more correction, the sanction which has been is given by the health department. The main work is the.
Sanction is, you see, you have only to verify
Lordship,
and you have got to give a proposal.
Lordship,
The proposal has to be sent to the Finance Department
Lordship,
for sanction of the amount, correct?
Lordship,
That's all.
that's all.
Only thing you've got to verify whether the chief engineer's office will verify whether he has done the work and whether the rates are correct and the estimated amount. Then the office of the PWD secretary will only act as a peon.
Lordship,
I mean, sorry, I'll
I understand.
send the file from here to the finance, get their approval and then come and then communicate to the chief engineer for payment of the money.
But the main work, which was issued was done by the health department. Health department will do that.
Okay, health department was done.
Lord,
So you are appealing for whom?
I'm appearing for PWD, but my instructions were also given by the Council for Health.
Look, the problem is you are looking after health,
PWD.
PWD plus finance.
Yes, Lord.
You are the council for all three.
Yes, Lord.
So for this year only for health.
For this case, I'm only appearing on the PWD department.
And who's appealing for health?
The main counsel who was appearing for her lordship, she's on legs, but she had instructed me regarding this.
So who's appealing for finance?
Then I can appear on finance as well. PWD and finance I can appear on.
You are appearing for PWD and finance.
And finance.
We'll make the necessary correction. Huh? 6. Tuesday, by Tuesday, you get the written instruction.
But can it be on 8th, Lordship? If
It's
possible.
okay.
Yes.
We will dispose it of on that day.
Lordship.
You see, because once the contract work has been admitted,
Okay.
the amount has been admitted, the question of getting the approval is only,
Formality.
huh?
A formality.
Formality, natural consequence of that.
Yes, ma'am.
Lordship.
Make major Lordship.
You're still using the judgment
Yes, ma'am.
for so many years.
Yes. ma'am.
I'm feeling guilty now.
All the best.
And you're also having no problem with the judgment.
Okay, already committee is there, they're examining it and thereafter distributing the money because they have not, the amount of work they have done, only they will get that particular.
Correct.
That
No, but-
committee is set up to examine and distribute.
When was the first judgment passed in this case? A long time back.
Long time back.
Around 4-5 years back, I think.
What 4-5 years back, my lord?
And you are still
Yes.
using. When I had first passed when the court had first passed the judgment, I didn't think that it would have been used time and again by everyone.
There are 76 work orders.
Okay, I know, right. So you use this page 97. Hana? Page 97. Follow this page 97 thing. Just come to page 98. That 2020-21 is correct?
Yes.
Correct?
Yes.
Then invitation IFB is also correct.
Yes.
Letter of acceptance dated 5/5/21 is correct?
No, my
No,
lord.
that is date.
For
That's changed.
3/5/21.
Okay, letter of acceptance in para 3 will be 3/5/21. And contract price of
49 lakhs,
49, comma,
00,000.
okay, 49 lakh, okay. Issue of notice to proceed with work dated,
Issue.
6/5. Is 89.
6/5, 21,
My lord, 4/5.
4/5.
4/5.
4/5/21.
Yes, 4/5. Please, 18.
Pertaining to package number,
My lord, 73.
No,
CND,
of the-
CND,
CND of the bill.
CND/73.
Yes.
Okay, show cause notice dated
86.
8/6/21.
Yes, ma'am.
Divisional engineer had again said 25 to 30% again, was it?
Yes, all. Only right.
And then reply dated
11. 11/6.
11/6/21. Again 50%, I think I have said. Terminated the contract by letter dated
12/6/21.
12/6/21. Okay, then para 5 same, okay, 6 same. This writ petition has been filed when?
At the beginning of this,
8/4/2025. Okay, that is in para 8. I think that's all.
That's-
Disposal. Okay, heard, Mr.
A Deka.
A Deka for the petitioner and Mr. S. Bora for
For now, 1, 2, and 3.
1, 2.
Also.
Okay. Disposal.
May I please your lordship, non-payment of contractual amounts. Lordship. This is the second round of litigation. Lordship, the admitted amount,
Ah.
page 40,
Page 40.
the admitted amount, lordship. Pursuant to the first one. Page 40, the copy.
No, madam, this is the second round,
Second,
correct?
in the first round.
In the first round,
order is at page
you had
25,
made a claim.
Lordship,
Now, in this second round, you have made another claim of additional claim.
lordship may come to the order of this honorable court, lordship. The amount, they have stated,
Page,
page, 27 operative part, lordship, page 27, paragraph 4.
27, yes.
The learned counsel for the petitioner, however, submitted that the petitioner is entitled to an amount of rupees 37 lakhs 17,279, and the total entitlement of the petitioner was not ascertained by taking into consideration the relevant materials by the respondent authorities. Then Lordship may come to para 6. From the materials on record, more particularly the documents kept on record and marked with the letter X, it transpires that the respondents in the PHE department have duly admitted that the petitioner is entitled to an amount of rupees 20 lakhs 31,817. However, the said amount has not been paid to the petitioner on account of non-availability of the fund.
Yes.
Then Lordship may come to page 28, paragraph 9.
Yes.
This court further finds it relevant to observe in view of the submission of the learned counsel for the petitioner that the petitioner is entitled to an amount of rupees 37 lakhs 17,279. Taking into account that the respondent authorities have, upon verification, found that only an amount of 20 lakhs 31,817 is payable to the petitioner, this court cannot adjudicate as to whether the petitioner is entitled to further amount beyond rupees 20 lakhs so and so. In that view of the matter, this court is not inclined
Okay.
to pass
So only to 20
the
lakhs was
balance
granted.
amount, Lordship, 16, after passing of this order, they have again re-verified the amount. And page 40 is the relevant part. They have admitted amount, Lordship.
Pre-verification is done by, the pre-verification is not done by the executive engineer, Lordship, neither by chief engineer. It is, the sign is the accounts officer, Lordship.
This we have received after serving a legal notice, this document from the department.
Verification of the accounts officer.
You see, accounts officer, who is he? He just looks after accounts. You see, you have done a contract work.
Lordship.
The contract works will have to be, measurements are done and recorded in the measurement book, in the MB book. And depending upon what is recorded there, then the amount payable is calculated. Then the accounts officer will have to give an explanation as to how he has made this, has come to this figure. Because he's not the person on the field. He's only a person in the office who makes his bills, who makes the account on the basis of what has been fed to him.
Lordship, since in the last order, the court has directed to pay the amount
You
of.
see, one thing could be that maybe he has been fed the correct data. The account,
Then that-
and you have, and the executive engineer has not given the correct data to you.
That can be,
That can be also.
that can be.
We'll issue notice. Heard Miss
A Taluka.
A. Talukdar, learned counsel for the petition, who submits that the petitioner is to be given the unpaid contractual dues amounting to rupees 16,84,672, which have now been admitted by the accounts officer in the which department?
Department.
In the PhD department. The petitioner's case is that the petitioner's contractual dues amounted to 37,17,279, for which she had filed WPC number
6424 of 2020.
6424/2021. Next part. WPC 6424/2021 was disposed of by an order dated 14/8/2023, with a direction to the authorities to pay to the petitioner the admitted amount of rupees 20,31,817 against the claimed amount of rupees 37,17,279. The petitioner counsel submits that subsequent to the above order passed in WPC 6424 of 2021. The accounts officer in the PH has admitted that the petitioner is liable to be paid, not liable to be paid the outstanding amount of 16,85,460. That is the difference between the amount claimed by the petitioner and the amount admitted by the respondent at the time of disposal of WPC 6424 of 2021. Issue notice returnable in 4 weeks, Mr. R.R. Gowai accepts notice on behalf of
All the respondents except respondent number 6.
all the respondents except respondent number 6, which is represented by Mr. M. Buya. This is a matter after 4 weeks to enable the response to file the affidavit.
Much obliged.
Published.
What, have you filed the affidavit in other writ petitions?
Yes.
This is going to be, this is going to come up or what? Have you, have you, on second?
I think second.
Second.
Okay.
But my lord, work was completed in 16 and 17. There is no communication in between. There is nothing in their repetition regarding the delay part, my lord. Why they are approaching after 10 years, my lord. That is,
But it is your duty also to pay.
that is, I
You cannot take advantage of the delay that way. You see, you have made them work. They have used their own money. You're not paying them.
have already filed our affidavit also in that case.
Since it's already fixed, let it be decided by the court is going to hear it. I don't know whose court is going to hear it.
Sir, it must have, before the court number 2, my lord.
Oh, so it's not fixed before any
It's
court.
not.
So whichever court is there, they will hear it.
Yes.
So the basic thing is, you see, if it has to be paid, I mean, if it is a fact that they have done the work and they have not been paid, they have to be paid.
Our part is how much money initially it was approved for the work, my lord. That is only our part in that case, my lord. We have filed affidavit on that part, my lord.
According to the state government, you have not paid the full amount.
Yes, madam.
That is not,
Given the details in our affidavit, my lord.
you have admitted to the fact that you have not paid the full amount.
Full amount, yes, that is
Then you have to pay.
the remaining, yes.
Ms. J. Gogoi, you are for the water resource department. And for you, the only thing is you have got to verify whether the claims of the petitioners are correct, that's all. If it is correct, then it has to be paid. And Brahmaputra board, who is appearing for Brahmaputra board?
I'm paying.
Brahmaputra board. And for Jal Shakti also.
Yes, madam. Because,
So you are appearing for both.
yes, ma'am.
So then your hands are, so either you swim or sink together, that's all. Right. Ms. K.K. Chowdhury, then pass it for the petitioner, others are the contractual dues of the petitioners have not received. Issue notice returnable in 3 weeks. Ms. A. Gyan appearing for the Jal Shakti Ministry Department
Yes.
and the Brahmaputra board submit that the affidavit filed by her in WPC number 1872 of
23.
2023 shall cover the present case also. Ms. J. Gogoi appearing for the Water Resource Department shall also obtain instructions as to whether the claim made by the petitioner in respect of the work in question is correct or not. The counsels for the parties submit that the matters are going to be heard, that similar matters are going to be heard on 2nd June. 2nd June. List the matter on 2nd June.
Pleasure. Because in the impugn order, 10 persons were affected, out of which two have already come before this court. And we have three have come, we have argued in great detail. Ultimately, there was a suggestion that a power of review is there, so if we can file a review, that can be an option. So, Honorable Justice Jamir was hearing, so he directed a review to be filed and keeping the matter pending. So they have heard the petitioners in review and they are supposed to pass the order, and Justice Jamir has fixed, I think, 5th of May for the matter, no? And they have to file the order by Monday, last Monday. So let it be listed. Six, that will be better. If the order goes in their favor, we will be covered. There will be no problem.
Okay, so the review is to be decided by the authorities. The matter pertains to suspension of your
Suspension
on
and
the
also
mining.
now they are giving after 60 days a termination.
So-called notice is required to be issued, so-called notice is issued, but the petitioner stated that they have not received the so-called notice. So I'll take the instruction of the
No, we
so-called
have
notice.
received, we have
Okay.
Okay, right. Asking for the parties submit that the matter may be listed on 6th, in as much as the review filed by the petitioner is going to be decided on 5th. The matter pertains to
suspension of the.
suspension of the mining of a stone quarry.
Right. Good job.
Just a matter of 6th.
Wait, please, Lordship, I am appearing on behalf of my senior Mr. Ahmad Kundagar. He is,
Appearing on behalf of
he is in another court, kindly pass on. for it.
Actually, we have received the instructions regarding this matter. We'll be filing our affidavit.
Okay, Mr. M. Barwa, M. Buyan, Senate Counsel for the PWD. Submit that instructions have been received and he will be filing affidavit within
2 weeks.
2 weeks. This is the matter of 2 weeks.
Next.
Wait, please, your lordship. Lordship, this is a writ petition challenging the.
Tuesday. Tuesday, quite a bit of cases. Find
Lordship, this one difficulty, I will not be here to, can it be listed after that if possible? From 7 to 15, I will be traveling.
no problem. Okay, right, on the press of petitioner, this is the matter on 16th,
16 then, Lord.
16th?
Thank you.
Your Lordship may look at the order, the last order dated 19/11/2024.
Yes,
No, we wanted certain documents because the few of the
Yes.
marine claims could not be settled. Because we wanted certain documents which they could not give it to us. Now possibly they will require some time.
Dispute was regarding those non-compliance of, non-fulfillment of those claims of ours. Now, that particular list of these people whose documents have not been furnished by us, if that list is given to me, then I can,
can you give the list?
Yes, sir.
Given the list, he'll give it.
3 weeks' time may be granted. In the meantime, this will be sorted out.
On the prayer of the parties, this is the matter of the civil.
Yes.
Obliged.
Obliged.
22.
Okay, in this case, an amount of rupees 2,77,956 is
Outstanding.
due as outstanding rent to the petitioner to be availed from the respondent number 6 as house rent for giving the office premises of respondent number 6 on rent for a period of 1/4/2015 to 30.
Yes,
Lordship, we'll need to obtain an instruction. This matter has updated instructions. This matter has come after some time, after almost 3 years.
Yes, because on 2/3.
so how much, what is the due amount
Due amount is 2,77,956.
as on today?
Most of, no,
That was in 22,
up to 39/2018, your lordship.
up to 80.
Yes.
After
from
that,
1/4
okay, so the same amount. So whether any amount has been paid, that is the issue.
Yes, please. We'll need to obtain an instruction.
Okay, Miss
Yes, that's good.
S. Das Gupta appears for the petition, while Mr. M. Buyan appears for the
PWD department.
PWD. The matter pertains to the claim for house rent amounting to rupees 2,77,953 for the period ending 30/09/2018. Correct?
Good.
Mr. M. Buyan shall obtain instruction as to why the house rent has not been paid to the petitioner till date. List the matter when,
2 weeks.
huh?
2 weeks.
On last occasion,
You see,
Yes.
it's a very simple thing. It is only with regard to why it has not been paid.
That's it. Might have
You
been
get-
paid as well. We don't know.
So why do you need to? You give a call,
But
you give a call, we'll take it up at 2, you give a call.
in that case, lordship can be taken up on Monday. We'll open an instruction for
Okay, Monday,
Monday.
give a call, and because it's a small thing, it might have been paid, so it's silly. But you also obtain instructions, madam, whether it has been paid, right? You're right also. The petitioner's counsel shall also obtain instructions as to whether the petitioner's claim has been settled in the meantime.
maybe we think of-
Come in as much as 3 years have passed since the last court. thing. Ready? Yes, what is to be done here?
May it please your lordship. In this case, we have admittedly completed the work. There is a completion report by the commander itself who has supervised the work, along with the executive engineer, PWD, who has prepared the plans and the estimates. And thereafter, they have gone on saying that we cannot pay you this and this will happen. No reason was cited. We claimed that we need to be paid. We came up before the court. And thereafter, there was a FIR against us. The court granted us a bail. And thereafter, they came up with an affidavit that there was a third-party inspection, that there was something, the work was not completed as per the requirements.
Lordship, we need to obtain an instruction.
What is happening?
No, they have already filed their affidavit.
Updated instruction as to what is going on with this case. Updated
What is happening? We have scanned it there.
Then lordship, it has come after quite some time.
No, 1 year only.
2022, I believe.
No, the last order is of 15/3/2024. 5534 of 2020, correct?
Okay, I'll have.
Yes. What has happened? When did you last speak to your client?
Your lordship, the issue was like, yes, I've spoken to my client, your
When?
lordship, 3-4 months back, your lordship. Your lordship, they have stated one thing, your lordship, that we have completed the work, we have handed over the site. There was a completion report, and there was a report from the commander itself, who is the authority, your lordship. And there is a joint report from the executive engineer, PWD, as well as the commandant that we have successfully completed the work. Now they have not made the payment, therefore we approach the honorable court, Your Lordship.
Where is the document showing the handing over of the
Yes, Your Lordship.
completed site?
Yes, Your Lordship. Your Lordship will kindly turn to page 51 of the writ petition. Has Your Lordship got it?
Yes.
Format 1 completion certificate. Progress report, Your Lordship, name of the work, then everything is given. Then Your Lordship will kindly see down below, physical progress 100%. Certified that the work so far executed by the opposite contractor has been verified physically by the DDO and found 100% completed as per specification drawing.
No,
and
this, where is this work done?
Your Lordship, it is at Mankachar, Your Lordship. That's a battalion, Your Lordship. We need to construct a barrack. There were several work orders issued in favor of various other tenderers. So I was allotted with construction of 4 barracks and 1 kitchen. So these are all temporary basis, Your Lordship. So I have constructed it. And that's the completion report, Your Lordship. And again, another completion report is at page 55, Your Lordship.
This completion report is dated,
Your Lordship,
no date.
no, Your Lordship, it's not dated, but Your Lordship will kindly come to, it's 411, Your Lordship. Why I'm saying so? Then Your Lordship will kindly turn to
What,
page,
411 what?
sorry, 2019. I'm
Page
sorry.
number 55, Lordship.
Huh?
Page
Page
number
number 55 is the forwarding report, Your Lordship.
Connection 12.
This is the completion report submitted by the commandant itself to the additional DGP. That's dated 4/11/2019. It's written, Your Lordship. With reference to the subject cited above, I have the honor to submit herewith the completion report of construction of the temporary barrack number such and such, Battalion Chammar Sali, South Salmara, Mankachar of total cost of 4,99,000. The duly filled up pro forma completion certificate format 1. That is at page 51, just I pointed it out. 3 copies of signed photographs of the completed constructions are enclosed herewith. I therefore request kindly to release the amount in the current financial year against Sri Krishna Enterprise, Kailipura, Assam to make the payment. So there was a completion report and the payment was not being coming, so we approached the honorable court. Your Lordship.
WPC?
This is 5534, Your Lordship.
No, this is, did you approach this court earlier?
No, this was the first answer, Your Lordship.
And now they're taking a stand that, is incomplete.
They have taken up a stand that they have done a third-party inspection. Thereafter, that is after a period of 1 year after handing over.
Where is that? Where is that?
If a lordship, they have not annexed the report. If a lordship takes up
Does
the,
that annex the report?
no. If a lordship kindly turns up the page 75 is the affidavit in opposition.
Yes.
Page 77 is the relevant portion, para 11, down below, Your Lordship. That with regard to the statement made in para 12 of the writ petition, the deponent begs to state that the government sanction was received for an amount of such and such amount under Moitri scheme, which also included the sanction of 3 barracks and 1 kitchen of 26th Assam Police Battalion to South Salmara. The sanction was accorded by the government under such and such scheme. As per the procedure of Moitra scheme, a third-party inspection is required, and accordingly, the AP headquarters wide letter dated 39/2020 directed the commandant to conduct a third-party inspection comprising of such and such person. So this this inspection was conducted on which date I don't know, but a letter was issued on 39/2022. Whereas I have completed the work on 4/11/2019 and handed over it. That was the report. So once you have taken the stand that I have completed the work, now can you turn around and say that I have not done this and that?
Correct. They should have inspected it prior to the
In
complete.
fact, they have inspected it. Therefore, the report was given, Your Lordship.
But it's like, sometimes it's like this cars. Foreign cars and
Yeah,
Indian
Lordship.
cars, the problem with the Indian cars will show within 3-4 years. Foreign cars after 10 years is still okay. So that time period is required also.
But your lordship, these are all temporary things, it's just constructed with bamboos and things. So maybe after 1 year, some defects may become because of the use wear and tear by those people. Or that we cannot
No,
fix.
but some, they are expected to last at least for 2-3 years. Maybe it's like the roads that are being built in our state.
But that
As
was,
soon as the rain come, it goes.
but as per the terms of the contract, I have completed the work and they have given a satisfactory report, your lordship. These are petty businessmen, your lordship. Again, dragging them unnecessarily makes no sense, your lordship.
Where is this Motri scheme?
Your lordship, this is something not reflected in their tender documents also.
I say, no, there,
No, it,
is
in
there,
the,
what is the agreement? Nothing, is there any agreement signed?
no,
No
it
agreement.
was, need of urgent works. So NIT was issued, we participated. We worked here.
Any advertisement issue?
Yes, your lordship.
Where is
I'll
the
just,
advertisement?
I'll just take your lordship to the NIT. That is at page 29, your lordship.
29.
We are actually the registered the contractor with the
Maybe.
police department, your lordship. If your lordship kindly looks at below your lordship, copy 2. Assam Police website for white publication, all local contractors for information, office notice board, your lordship.
Yes.
Sir, in any case, I believe that the tender was issued by the police department.
No, they are for the,
No, I'm for PWD.
yeah, for the PWD.
No,
He is the authority who has prepared the estimates and who has also given a completion report that.
In fact, the work is done under the supervision of the PWD.
PWD was done with that. Otherwise, lawsuit in our affidavit lawsuit in case, paragraph 11, just lawsuit says that they are without lawsuit.
Page?
Is
76, 77, your lordship.
Yes.
let me,
Just
I
now,
will
which I have-
down to page 79 lawsuit. Page 79 lawsuit. Page 79, above the paragraph 12 lawsuit, that subpara lawsuit, T subpara. The report also says that the construction works are not completed as per the approved estimate. As such, payment could not be released to the petitioner, rather he was asked to complete the unfinished work.
But then the PWD has given the completion certificate, and the commandant has given at page 51.
Both of them has given it.
Page 51.
That affidavit was filed in lawsuit probably 2020, 22.
So, makes sense.
You see, page 51. This is by the commandant,
And
executive engineer is at page 54.
Commandant lawsuit, that was from 2019 lawsuit, that.
Correct. So if it was completed in 2019,
The committee found that lawsuit, it is not as per the estimate lawsuit. Committee, as per
the committee, was the committee the supervisor? Was the construction done under the supervision of the committee?
It was not done because there was some discrepancies is there, so the committee was lawsuit formed.
I mean, come on.
And otherwise, lawsuit in the affidavit is filed in 2022. My lord may give some time, I will take the updated instruction also. After that, what is happening? Lawsuit?
What update is taken?
So regarding payment, again lawsuit, the 1, 2 of the documents we have annexed lawsuit.
Paying, it's clear. Your affidavit says that you are not paid.
Lawsuit.
Why should you pay? Why should you pay when you say that it's not completed?
Then lawsuit, whether he has, that part is compliant with or not, that
No,
part.
no, then you see, only one thing I want to know from you. Was this contract work done under supervision of the PWD or the committee?
That part was, otherwise probably it is under the PW, not the committee lawsuit, not the committee lawsuit. That's because some discrepancies is there lawsuit here and there, that's why one committee was constituted lawsuit. It is there lawsuit. Otherwise lawsuit, it is as Even
And
lordship,
you said it is done under the MOTRI scheme.
even lordship,
What is this scheme with the no
it's a,
document, nothing?
it's a central government scheme lordship.
So it can, you see, a number of works now are done under the central government. scheme. That doesn't mean that the central government scheme that a constitute, committee formed is formed under the scheme and that the works are done under the scheme. There's nothing like that.
That is not there.
You look at your PMGSY,
Otherwise
it's all done
also,
under the supervision of the PWD. You see your under the electricity department, so many, under the electricity department of the state. So many.
otherwise lordship, that particular committee also lordship from the persons from the PWD department. My lord, in page 78 lordship.
No, I don't know that. Whoever the committee may.
Lordship.
You see, when the completion certificate has been issued in 2019, where is the case for saying 1 year later that it is
Lordship,
not
lordship.
completed? Unless you can say that the completion certificate is a fabricated document, then you take action against the commandant and the executive
Lordship
engineer.
may give 2 weeks or 10 days time, lordship, I will come up with a technical instruction, lordship. Otherwise, if I am failed to come up with an instruction, then on the basis of that page 29, my lord may dispose of the matter. lordship.
I have time to dispose of now. Why should I wait?
Otherwise, lordship, that why lordship, that committee was constituted, that query lordship, I have to lordship obtain from the authority lordship. After giving the completion certificate for that committee was. That
Yeah,
part I will obtain.
This is because you have got no money to pay him.
No, money is also there. Your
That is not there.
Money is there.
It was there.
That is-
money
Sanction
is-
was approval. Something, these are young businessmen.
Because
Something happened between the commandant and
Yeah,
the businessman.
here the
They
stand is-
refused and thereafter all these steps are taken.
As
in.
part of affidavit also, the stand is, money is not there, that is not the stand lordship. Otherwise lordship, only reason is that
No,
lordship.
but then you see, once the commandant has signed, the concerned engineer has signed, what remains?
That part is there, otherwise lordship may
I've
give-
never heard as a lawyer or as a judge. This is the first time I've heard of a committee requiring to give a completion certificate. Give me an instance. You give me your
committee-
instance
lordship,
as per your
committee-
instance.
Committee is not the completion certificate, he is just inspecting lordship whether it was as per the estimate.
Can
of the-
a committee decision supersede a completion certificate given by the concerned authority?
That part lordship, whether he is the competent authority or not, lordship, commandant.
If he's not, if he's not, then you take action against him. Why is he
Lordship
given?
may give at least 10 days time, lordship, I will come up with a instructions whether he is the authority to give. the
And then you
completion
also
certificate.
you bring me instructions with regard to whether the committee is the competent authority to
Lordship,
give.
lordship, I have both instruction. I will
More
come up.
importantly, your worship, the report has not been annexed.
Nothing has been annexed. The mortuary scheme, nothing has been.
And more importantly, when they have gone to inspect,
No
I was
inspection
also
report, nothing.
I was also not in. This is only an afterthought, only to harass.
Appears. Anyway, right. Heard Mr.
Ours.
R. Sinha, the counsel for the petition, and Mr. K. Gogoi for
See, I am for exponent number, lordship,
He'll appear. for
1
respondent.
to 5, lordship, 1 to
1
5.
to 5.
1 to 5. lordship.
Mr. M. Buyan appears for point number 6. 6 and 7. The petitioner's case is that,
Finances for 8 years.
finance,
6, 7, and 2.
yeah, for 8 also. The petitioner's case is that pursuant to a NIT dated
14/8/2019.
14/8/2019 issued by the office of the
Commandant
Commandant 26 AP bracket IR
Battalion.
Battalion, Chamra Sali, South Salmara, Mangtacha. The petition was awarded with the construction of a temporary barrack number
26, 27,
26,
28.
27 and 28
And a kitchen number 5.
and temporary kitchen number 5. The petitioner completed the construction work and consequently completion certificates were issued by the executive engineer,
And commandant.
just a minute. Executive engineer, PWD Dubri Building Division, and the commandant of the 26 AP bracket IR battalion. With a forwarding letter dated, no, forwarding letter number 26/IR/Q/completion report /2019/1021 dated 4/11/2019.
There are 4 completion certificate, Your Lordship.
Comma, dated one, and then,
The last one.
then
is
just a minute. 57, page 57 is another number and date. Then 59 also is there, and
61.
61, the numbers are there, okay? Dated sensor, all dated 4/11, issued by the commandant 26 AP bracket IR battalion, comma, informing the additional director general of police, comma, Assam, regarding the completion of the construction work by the petition Two of sentence statements as follows, huh? Next, on the oral prayer. Next, on the oral prayer made by the petitioner's counsel, the commissioner secretary to the government of Assam, finance department, is implemented as respondent number five.
It will be five.
Number five, huh? Uh, the petitioner's counsel shall submit a corrected copy of the cost title to the registry within 3 days. Issue notice to the finance department, to the respondent number five. Mr. M. Buyan accepts notice on behalf of Mr. B. Gogoi, standing counsel for the finance department. Next paragraph. In view of the fact that the amount claimed by the petitioner has been admitted by the PHE department, and the only reason given by the PHE department,
Irrigation.
the irrigation department, for non-payment of the admitted amount is due to lack of funds. The finance department would have to make funds available to the PHE, to the irrigation department for payment of the admitted amount.
My friend is sitting little over. PhD is sitting here.
Next para. In view of the reasons stated above, the respondent shall ensure that funds are made available for payment of the admitted amount to the petitioner. The payment of the admitted amount to the petitioner shall be completed within a period of shall within a period of 3 months from the date of receipt of a certified copy of the
Let it be 6 months.
6 months from the date of receipt of a certified copy of the document. 6 months too much. 4 months.
Finance.
4 months. First up, 4 months, huh? Right. In this respect, the respondent number two, 1 and 2 shall ensure that a proposal for sanction of the required funds is made to the finance department within a period of 2 weeks from the date of receipt of a copy of the sort. This petition is accordingly disposed. So you've got to do 2 things. One is
Finance.
cost title, corrected one. Number 2, give your letter fast, give the order fast. Within 2 weeks, they've got to submit to the finance department.
Yes, sir.
27.
Yes. Can we fill all the 27 moment?
Huh?
Last one. Finance department was directly to obtain instructions. Matter point,
Any affidavit filed?
the home department has filed admitting, well, they have said they send the proposal to finance. That's why on the last occasion, finance department counsel, Mr. G. Gogoi, he was directly to obtain instructions.
Mr. B. Gogoi's pin is here. He's in a predicament because B. Gogoi is somewhere else. He has to take the brunt of everything. Yes, what to do? Okay. After something?
Yes.
Anyway, it's at 2 o'clock now. Oh.
Well, 2 weeks, for a time may be allowed to file. Vehicle of the petitioner was requisition member.
Huh?
Vehicle of the petitioner was requisition member.
Anyway, let him file the affidavit. Right. Mr.
He has on
P. Hazarika on behalf of
SR.
S.R. Raba, land counsel for the BTC, is granted 3 weeks time to file affidavit with respect to the claim for payment of vehicle hire charges. This is the matter after 3 weeks.
Lordship. Budget notice of motion was issued.
Instruction is given.
Mr. R.R. Goel, then counsel for the PhD department is granted 3 weeks time to file the affidavit. This is the matter. With regard to the claim for payment of contractual dues.
Item number 13 will be similar.
Item number
30.
30 also same.
Instruction is given.
Huh?
We receive instruction,
You have received instructions in both.
both.
Acha, in 29 also you received
Yes,
and 30 also.
yes.
So when are you filing? How can we dispose it of
You
them?
can disclose it, our lordship.
I thought you did not have. I thought you said that you wanted time for it. Okay. 29 and 30 we dispose of. Okay. Item 29, you're right. Heard Miss Diangana, Learned Counsel for the petition. And Mr. R.R. Goel, Learned Counsel for the PhD department.
Department.
The petitioner has made a prayer for payment of his contractual dues amounting to rupees 3,83,889. Pertaining to the work pertaining to office order number, para 5, correct? Para 5. Office order numbers, it's okay. The various orders are there.
7 work orders.
In the pertaining to 7 work orders, which are as follows, para 5. Mr. R.R. Goel, Learned Counsel for the PhD department submits that as per the para-wise statement given to him, while forwarding letter dated 18/1/25 issued by the executive engineer PhD, Guwahati Division number 1. The pending liability of the petitioner amounts to rupees 3,23,329. Next. I have heard the learned counsel for the parties. The para-wise comments and the forwarding letter dated 18/1/2025 issued by the executive engineer PhD, Guwahati Division North 1 are made a part of the record and marked as Annexure X collectively. As the claim of the petitioner is an admitted amount. Correct?
No, admitted.
No, as the claim of the petitioner by the respondents is limited to rupees 3,23,329. The respondents are directed to pay to the petitioner the said amount within a period of.
Yes, there were directly to the chief and verify a lordship because this instruction from the executive engineer.
Okay. The admitted amount, This court is of the view that admitted amount in terms of the letter dated 18/1/2025 issued by the executive engineer PhD, the claim of the petitioner be re-verified by the chief engineer PhD in terms of the decision of the full bench of this court in the case of Tamsher Ali versus State of Assam and others reported in 2008. 8 GLT, what is it?
4 GLT1.
Huh?
4 GLT1.
4
4 GLT1.
4 GLT1, 2008. Full stop. Thereafter, the admitted amount to be paid to the petition. The entire process should be concluded within a period of
4 months.
4 months from the date of receipt of certified copy of the fund.
Finance is not being made a party of that. So.
I have to file lordship for implement of finance.
Okay, you just write, somewhere, yeah, just write. On the oral prayer made by Ms. D. Angara, Learned Counsel for the petitioner, the Commissioner Secretary to the Government of Assam, Finance Department, is made, is treated as the following number.
Five.
Five. Huh? Five, the petitioner can submit a corrected copy of the cost title to the registry within 3 days. Issue notice to that's point number 5. Mr. M. Buyan accepts, M. Buyan accepts notice on behalf of point number 5. On behalf of Mr. B. Gogol, Learned Standing Counsel for the Finance Department. Extra copy of the writ petition be provided to Mr. M. Buyan during the course of the day, by today. And in the earlier matter also, huh? You give in that other thing also. Who was that counsel? Huh? Who is that counsel? You tell him, you give that also. The writ petitions accordingly reported. 30. Same
Same, but amount is different.
amount, huh? No, that's what it is. It's structure is there. you see. Okay, everything same. Amount claimed and the amount admitted is same? No.
No.
Amount claimed is 308,767. Huh? And the amount admitted is 206,297. Okay. Then out here, everything else is the same. Way. No. Work orders will be different.
Work order.
And actually acts collectively, huh? Or they are also act collectively. So out here, work orders are at page para 5 again. How many work orders?
6.
6 work orders, okay.
Public.
So you have got to give this one also, photocopy.
Public.
I will check. You kindly see the last order number,
Last order.
26-3. As per order number, the education, standing council education department.
Reverse approval? For want of reverse approval? What is reverse approval?
The education department says that due to the reverse approval, they are not paid the amount member. PWD department already filed the affidavit.
Lordship, here I need some more time to obtain my updated instructions and offer.
What is this reverse approval?
Reverse approval, your lordship.
A reverse approval? I've never heard of a reverse approval. How can you give approval in reverse?
There is a communication, my lord.
There's a communication says reverse approval.
27,
And what is direct approval then?
9, 30.
They write the sentence backwards or something? Reverse approval. No, revised the approval, not reverse. Is revised. What you also? You see, when there is a revision of the rates,
Division of the.
So the so there has to be a revised,
Yes, your lord.
but then why should there be a revised approval? Was there a revision of rates? Was the rates revised?
It maybe there is some, the additional amount was, uh, rate was enhanced, madam.
So
Why
that,
does-
so that revised approval
Revised
for the approval for the revised rate has to be given. Yes. So what is to be done?
I'll need some more time, your lordship.
For what?
On the last occasions, I have been instructed to obtain the.
Reverse approval.
Yes, your lordship.
Reverse approval you'll never get.
1 week time, your lordship, on the next day.
Okay, right. Miss H. Tarangpi, learned counsel for the secondary education, shall obtain instructions as to why the um, administrative approval for the revised rates has not been given till date. Now, as to whether the administrative approval for the revised rates has been given. This is a matter after a week.
Date may be fixed.
No hurry, Mr. Counsel. He will not have it with him. Okay, give a date after, not 1 week, you say 3 weeks. Give a date after 3 weeks.
Also, we have paid my immediate waiting lordship that we have.
What is this matter?
Versus non-payment of contractual bill, the immediate amount is, it is now 42 and 42, it can exceed. Surrender
Huh?
surrender works.
And was it accepted?
Yes, already in page number 42, they have admitted the amount.
What does the contract agreement say? What does the contract agreement say? And the maintainability of the writ petition is kept open also.
Yes. So I'm filing my affidavit by the next week. Lord.
You see, Mr. Upadhyay, on 1 month earlier, you have said that you have received instruction.
Yes, Lord, I have prepared my affidavit, I sent for it for vetting.
Mr. Upadhyay, learned standing counsel litigation department submits that affidavit has been made, has been prepared, and the same has been sent for vetting. He accordingly is granted a further 3 weeks time, huh? 2 weeks time.
2 weeks.
2 weeks time.
6 months. 2 weeks.
To file affidavit. This is the matter of.
Always.
In this matter, we have made the affidavit and sent for vetting, madam.
Lordship, as per a order, Lordship, communication passed by the assistant director, Lordship, the petitioner has the ration card above 50. This communication.
Let him file his affidavit.
Lordship, my shop has been tapped, Lordship. I am
What is that?
suffering. Page 50 may kindly be paid for a moment.
Page
50. 50, Lordship.
Yes.
By this order, Lordship, my shops have been kept with other shops, Lordship. So I am without shop, my livelihood is affected, Lordship. And The communication which I have referred Lordship, by this communication Lordship, the Assistant Director Lordship for Civil Supplies informed the Commissioner Lordship that all along my charge are above 50%.
See, in this case, we have on the actually for vetting lawsuit, extra lawsuit, we have sent it for vetting. As for the inspection lawsuit, below 50 lawsuit, there,
This is for the year, which year? 21.
21 Lordship, that
Then-
is the relevant year Lordship. Lordship. Then the EPOS device, point of sale device was distributed on 26/6/2021 Lordship. It is indicated.
Let me file the referee.
okay, when lawsuit, our, as per our inspection lawsuit, at the relevant point of time on 26/6/2021, that the consumer is less than 50 lawsuit.
Here, given this
I-
document, have you given a copy to them?
Yes, I have received it from also Commissioner and Secretary for the Civil Supply Department.
No, have you seen the document?
Lawsuit, I will go through this,
So you see that?
lawsuit.
Okay, right. Mr. R. Islam, learned counsel for the petition, has submitted. Letter dated 13/3/2025, issued by the Assistant Director, Food and Civil Supplies, Food,
Civil supplies and
Public Distribution, Consumer Affairs, is it?
Lawsuit.
Which
Goshaigaon.
shows that the petitioner had ration card hold, petitioner's shop, FPS shop, Fair Price shop had ration card holders above 50. The relevant months of 2021. Mr. A.O. is the counsel for the respondent shall obtain instructions with regard to the above. He also submits that affidavit has been set for vetting
Lawsuit.
and the same will be filed within
Within a period of lawsuit, 10 days will file.
within 2 weeks. This is the matter.
Yes, there is pending.
Lawsuit.
Time being until 27. Lordship, here, Lordship, the Home and Political Department, Lordship, as per the affidavit, Lordship, they have stated there is some confusion, Lordship, because they have not been able to provide us with the CA proposal which they have claimed to have sent us. And now, Lordship, if they had sent it for the year 24-25, Lordship, that financial year is over already. Now we are in the year 25-26, for which a fresh budget is already allotted to the Home and Political Department. Only if there is any shortfall, that is when any extra additional budget is required. That is when the approach to the finance department is made, Lordship. Here I have gone through the affidavit, Lordship. Here there seems to be some confusion, Lordship, in page number 44. Lordship, if I may read, Lordship, the second last paragraph, Lordship. The deponent in page number 44 that has been filed by the Home and Political Department, Lordship.
Affidavit,
Yes, Lordship, they have filed an affidavit. here.
page, para?
Page 44, Lordship, para 11, Lordship.
Yes, para page 44, yeah.
Page 44, second last paragraph.
Yeah.
The deponent humbly begs to say that since Home and Political had not received any final bill from PWD after completion of the work in the financial year 23-24, no budget provision could be made available for sanction and release of the balance amount of rupees 6 crores. However, Finance Department is being moved for a CF advance for making budget provision in the current financial year 24-25. A meeting was held.
Now that is gone, 24-25.
Yes, Lordship, here they have also, in the last 3 lines, Lordship, there's an additional chief secretary along with senior officers of Home and Political to discuss matters pertaining to pending liabilities of Political, wherein it is decided that amounting to more than 5 crores will be moved to clear the pending liabilities of the client, which is under process, and the CF proposal is already submitted to the Finance Department for making budgetary provision. Lordship, here the CA proposal has not been annexed, Lordship, and now this year is already over, Lordship. Here, if my learned friend can show anything that they have approached the Finance Department in the form of a proposal, Lordship, I can obtain my instruction. or if Lordship may grant me, I can, by Friday also, Lordship, I can get the instruction whether any proposal have been sent or not. Now, our issue is like, the proposal was sent for the final.
Which is the department, personnel department?
Lordship, here, the work was.
PWD.
Yeah.
PWD.
Under PWD.
PWD and
It's a
the-
construction of the Assam Human Rights Commission building, huh? The work is construction of Assam Human Rights Commission building.
That is completed.
It was functioning fine.
I was there for the inauguration of.
Lordship, if the
That was actually during, whose time? Justice Ayer's time. No. Doesn't feel happy. It is better now.
Yes, Lordship, because
Yeah, maybe there is a very short time.
Anyway, there is no dispute regarding the construction or handing over, like, there is no dispute about
Only
that.
thing is they got to pay.
yes, Lordship, and if the payment, because the new financial year has already started, so budget is already provided, Lordship. I doubt it will be exhausted at this early stage, Lordship. So if, if any,
Who is appearing for the department, PWD?
and the moment
Senior government advocate D na,
D,
Dipankar na.
tell him to come here.
Lordship, if a copy of the proposal is sent to us, Lordship, we'll immediately furnish.
So we will take up at 2, I will inform you.
May I please your motion? I am appearing as study counsel in Excise Department in this case. Also, I have ready my affidavit, but the deponent signature is required, so some time may be given. I have already.
Okay, right, no one appears for the petition on call. Miss
And Miss Korobi Saikia.
K. Saikia, Learned Senate Council Excise Department submits that the affidavit is ready. And the same is will be filed whenever the deponent gives his signature to the city.
Yes.
He submits that the affidavit will be filed within a week. By next week.
Okay, Lord. 10 days time maybe at least. 10
Why?
days.
For signature, how long?
Okay, yes. 1 week.
Within a week. This is the matter after a week.
Applies first.
I appear for the respondent FCI Lordship. We request some further time to file affidavit in opposition. in-
What about you?
I have no. This one was headed in the.
No, so you're not filing any affidavit. Mr. Miss, Madam Devi,
Okay, I am having that. Okay,
for
7 and 8 documents.
Miss K. Devi, submit, Miss R. Devi, submit that she'll be filing affidavit on behalf of this warrants number 7 and 8 during the course of the day. Here in item number, in item in WPC 1316 of 2025 and 6549 of 2024. Okay. Then, Mr.
Yes, sir.
P.S. Bhattacharya appeals for the response number 7 and 8 in WPC 289 of 2025. Huh? Are you filing? And who submit that he will be filing affidavit within 4 weeks. Miss,
I appear for respondent number 1 to 6 in all the 3 writ petitions. I'm A. Chakraborty.
Miss A. Chakrabarti appearing for the respondents number 1 to 6 in all the writ petitions. Submit that she will be filing affidavit within 4 weeks. This is the matter of proposal. Obliged.
After a lordship was inclined to take up for disposal to.
I don't know, depends upon your.
I am otherwise prepared. Lordship, so in a nutshell, what has happened? Petitioner had participated in a tender process. On the last day of submission of bids, they issued a corrigendum, first extending the date of submission. The next day, they have changed the eligibility criteria.
So extending is not a problem.
Extending is not a problem.
So they changed the eligibility criteria.
Eligibility.
What was the eligibility criteria earlier?
The earlier eligibility criteria required, in a nutshell, to provide financial experience of doing a similar work of value of 2 crores, 3 lakhs.
2 crores 3 lakhs.
Three
Where, let us see, where is
Yes.
it page?
The lordship will find the eligibility criteria at page number 23.
Page 23.
23.
Yes.
Clause number 5. The bidder should have experience of executing at least one single work order of similar nature, government supply work order, minimum 34%. This 34, since the total value of the work is 6 crores, 34% comes to 2 crores, 3 lakhs, 99,660. 2 crores, 3 lakhs, 99,660.
660.
660. And the annual financial turnover, minimum 67% of the tender value in 1 year during the last 5 years, updated to present price level. The tender value, your lordship, is at page number 80 at 6 crores. So this is.
Page number 80.
Yes, the tender value, your lordship, will find at page number 80. Also at, yes, at page number 80.
No, where is the,
So on
Yes.
the last date of submission of bids was 10th of March. As per the schedule at page number 19.
10 March
10th
20,
March, 10th
24,
March 2024. 10/3/2020.
24.
25.
And NIT was dated?
NIT was dated 13/2/2025.
Yeah.
So on 10/3/2025, your lordship, they issue a corrigendum, which is at page number 33. This is the first corrigendum.
Page
33. They only say that the tender published by reference number so and so and uploaded by so and so. The last date has been extended up to 23/2025 due to some technical reasons. So they extend the last date on.
Yes.
After doing that, your lordship, on 14th, if your lordship turns to page number 34, on 14th, a modified tender bidding document is uploaded. The publication date is reflected on the e-portal. Publication date is 14/3/2025. So after extending the last date, they modify the tender condition
So last date was extended till what date?
till 23/2025. So on 14, they upload the only change, yes, everything is identical, is a clause number 5, your lordship, at page number 42.
Yes.
The bidder must now the clause reads as the bidder must have experience of executing and completing at least one supply order of wooden desks and benches with iron and steel frame of government of BTC in education department. So they need it specifically from the education department of BTC during the financial years 22/23, 23/24, and 24/25 for an amount not less than 2 crores 40 lakhs. So it is
Yours is 2 lakhs, 2 crores,
3
3
lakhs.
lakhs.
So around 47 lakhs is increased. So if
Around 37 lakhs.
no, it was 2 crores, 3 lakhs, or around 37 lakhs, I beg your pardon, around 37 lakhs. Around 37 lakhs is increased. So if this 37 lakhs is increase of 37 lakhs, that your lordship will examine what is the objective criteria that they cannot decide the financial capacity of a person at 2 crores, 3 lakhs. And at 2 crores 40, they, according to them, then only then a person becomes financially eligible to do the work. But apart from that, once the bidding has, the tender process has started. On the
Not started.
The-
It started in a way, but then it has not been opened, nothing has been opened. And it is not the last day.
No, they have increased it. The conduct will have to be, your lordship, seen, because on the last date, they have extended the date, then changed the eligibility criteria. And I had participated prior to that.
There is a decision, latest decision of the Supreme.
Yes, I went through that judgment, your lordship.
So there, I mean, first of all, from Ramana Dayaram Shetty onwards, the Honorable Apex Court has held that apart from Article 14, even under the principles of administrative law, there is some degree of, at least a bidder has a right to be fairly considered. So in Tej Prakash Pathak case, the recent judgment, the Supreme Court has said that it was in the line of contractual appointments, Your Lordship, that the recruitment process starts on the date of the advertisement. And the finding of the court was that once the eligibility criteria for a stage of evaluation has been announced, till it concludes, it cannot be changed. So that would mean that on the date the advertisement has been issued in that case, and the criteria have been announced, until it is finally concluded and the results are declared, it cannot be changed. Here, what they have done, they announced the criteria. I have participated. There was a significant amount of earnest money and tender amount that is besides the matter, but I have participated. After that, they have extended the tender and then changed the eligibility criteria. And changed it how? By just increasing it by 37 lakhs. It appears that the condition is tailor-made, probably to meet some, I mean, that is another factor of the aspect of the matter which will have to be gone into. Because in the affidavit, they have not said that what is the objective criteria, how this increase of 37 lakhs satisfies the need of the authority to financially evaluate the financial capacity of the bidders. So if I may take your lordship to the judgments, these are the facts in a nutshell. There is no dispute with the facts. So I'm relying on 4 judgments, your lordship. Mirror Development, Dr. Associates and Ramana Dayaram Shetty to show what is the, besides Article 40, there is one, I mean, the standards of fairness and transparency which is expected from a tendering authority, it transcends Article 40. That's what the Honorable Apex Court had held in Ramana Dayaram Shetty. And in Tej Prakash Pathak, one of the very important findings is that the Honorable Apex Court has held that Article 14 is in the nature of a genus. And the subsequent articles 16, 17, 18, 19 will also be covered. They are the species. So once you violate any of the rights under any of the subsequent articles, then Article 14 automatically gets applicable. So I will place the judgments.
Yes.
If I may first take your lordship to one paragraph from Ramana Dayaram Shetty, I will not read the entire thing. The paragraph number 10.
Yes.
Now there can be no doubt that what paragraph so and so of the notice prescribed was a condition of eligibility which was required to be satisfied by every person submitting a tender. The condition of eligibility was that the person submitting a tender must be conducting or running a registered second-class hotel or restaurant, and he must have at least 5 years experience as such. And if he did not satisfy this condition of eligibility, his tender would not be eligible for consideration. This was the standard or norm of eligibility laid down by the respondent number 1. And since the respondent number 4 did not satisfy this standard or norm, it was not competent to respondent number 1 to enter in the tender of respondent number 4. It is a settled rule of administrative law that an executive authority must be rigorously held by the standards by which it professes its actions to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. This rule was enunciated by Mr. Justice Frankfurter in Budgetary versus Saturn, where the learned judge said, an executive agency must be rigorously held to the standards by which it professes its actions to be judged. Accordingly, dismissal from employment is based on defined procedure, even though generous beyond the requirements that bind such agency. That procedure must be scrupulously followed. This judicially evolved rule of administrative law is now firmly established. And if I may add rightly so, he that takes the procedural sword shall perish with the sword. This court accepted the rule as valid and applicable in India in A.S. Ahluwalia and versus Punjab, and in subsequent decisions given in Sukhdev versus Bhagat Ram. Justice Matthew quoted the above referred observations of Mr. Justice Frankfurter with approval. It may be noted, this is relevant, Your Lordship, that this rule, though supportable as an emanation from Article 14, does not rest merely on that article. It has an independent existence apart from Article 14. It is a rule of administrative law which has been judicially evolved as a check against exercise of arbitrary power by exercising the arbitrary power by the executive authority. If we turn to the judgment of Mr. Justice Frankfurter and examine it, we find that he has not sought to draw support from the rule from the Equality Clause of the United States Constitution and but evolved it as purely as a rule of administrative law. Even in England, the recent trend in administrative law is that discretion, as is evident from what is stated at pages 540 to 41 in Professor Wade's Administrative Law 4th edition. There is no reason why we should hesitate to adopt this rule as a part of our continually expanding administrative law. Today, with tremendous expansion of welfare and social service functions, increasing control of material and economic resources, and large-scale assumption of industrial and commercial activities by the state, the power of executive government to affect the lives of the people is steadily growing. The attainment of socio-economic justice being a conscious end of state policy, there is a vast and inevitable increase in the frequency with which the ordinary citizens come into relationship of direct encounter with the state power holders. This renders it necessary to structure and restrict the power of the executive government so as to prevent its arbitrary application or exercise. Whatever be the concept of the rule of law, whether it is the meaning given by Dicey in his The Law of the Constitution or the definition given by Hayek in his Road to Serfdom and Constitution of Liberty, or the exposition set forth by Harry Jones in his The Rule of Law and Welfare State, there is pointed out by Matthew Justice in his article on the Welfare State Rule of Law and National Justice. In Democracy, Equality and Freedom, substantial agreement in juristic thought that the great purpose of the rule of law notion is the protection of the individual against arbitrary exercise of power wherever it is found. It is indeed unthinkable that in a democracy governed by the rule of law, the executive government or any of its officers should possess arbitrary power over the interest.
Normal thing.
Yes. Then if I may take your lordship, just 3 paragraphs of merit. I'll not read it out, your lordship. I'm saying that the conditions that they have brought forth are tailor-made to bring in certain blue-eyed boys which they want to favor in the tender process. It has no objective relationship with the objective of the tender, the eligibility criteria, and in the affidavit also they have not said so. They have only said that as the we will take it up to fair report. Lying on the judgments in Ramana Dayaram Shetty Datta Associates and Mira Development Authority to establish that the requirement of administrative fairness under Article 14 and the subsequent articles, that is definitely amenable to judicial review. And apart from the gross arbitrariness in just increasing the financial requirement by 37 lakhs, even the procedure adopted to incorporate such requirement, your lordship, that is very unfair. So for that, if I may take your lordship to the judgment in Tej Pratap, I'll just place the relevant paragraph. It was in relation to a employment process, but the principles laid down, your lordship, perhaps that will be applicable. Perhaps. Yeah. Because in Ramana Dayaram Shetty, the Supreme Court has held that the requirement of fairness under Article 14 and administrative fairness, that still remains, your lordship. So the principles can perhaps be adopted, your lordship. That is my submission. Because once you have announced some eligibility criteria and people have acted on it, on the last date you extend the date and then change the same criteria, that would perhaps amount to changing the rules of the game.
No, but then, no, so the issue is with the change criteria, you became ineligible?
I became ineligible. I'm ineligible.
So even if time had been given to you,
Yes.
as had been done, you could not have changed.
I could not.
Your position would have remained the same.
Would have been. So if I may take your lordship to the judgment of Tej Pratap, here what had happened, the High Court of Rajasthan on the administrative side had issued an advertisement filling up of certain posts. So initially there was a requirement that in the written examination, there has to be the candidate has to secure 75% marks. But before the advertisement was issued, that requirement was removed. Now, after the advertisement, and examinations were held. The Chief Justice on the administrative side laid down a requirement that only those candidates who have secured 75% marks will be called for the interview. So in that background, Your Lordship, the matter traveled to the Supreme Court. So there two vital issues were decided, Your Lordship. When does the recruitment process commence? So that will perhaps have some application here, because when does the selection process commence? The principle will be adopted. Because here also, they are trying to say that even after the tender notice was issued, just because they have merely extended the last date of submission of bids, they can change the eligibility criteria. That is their case in a nutshell in the affidavit.
Correct.
Yes. So the findings of the apex court, when does the recruitment process set to commence? That will have a bearing on this matter. And then the findings regarding change of rules of games.
But this is a contract matter.
This is definitely, this is a contract matter.
Well,
So once you have, otherwise,
this is, so this is basically what, an offer for an offer.
this is an offer. So, and
For an
after
offer.
I submit my bid, so I have acted on the offer. And then you change the, because it's a call for offer, I have,
Anyway, okay, give me the.
Yes.
paragraph.
yes. The relevant paragraph, Your Lordship, paragraph number 21, the
21.
issues have been laid down, Your Lordship. At page number 20 of the judgment. Analysis, page number 20, paragraph number 21.
Yes.
To effectively analyze and adjudicate upon the questions referred, we divide our discussion into the following parts.
20. Tej Prakash.
Tej Prakash.
This is submissions.
No, paragraph number 21, Your Lordship. At page number
21.
21.
Okay, 20, okay, 21.
21.
Yes.
To effectively analyze and adjudicate upon the questions referred, we divide our discussion into the following parts. 21.1a, when the recruitment process commences and comes to an end, and 21.2b, basis of the doctrine that rules of the game must not be changed during the course of the game or after the game is played. So these are the two issues which would have a bearing on this case. So if I may read paragraph number 22, where issue A is discussed. The process of recruitment begins with the issuance of advertisement and ends with the filling of notified vacancies. It consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications or elimination of ineligible candidates, conducting examinations, calling for interview of viva-voce, and preparation of list of successful candidates for appointment. Then paragraph number 23, the basis of the doctrine of change of rules of game. The doctrine proscribing change of rules midway through the game or after the game is played is predicated on the rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of the application of the concept of equality enshrined in Article 14. In other words, Article 14 is the genus, while Article 16 is the species. Article 16 gives effect to the concept of equality in all matters relating to public employment. So similarly, Your Lordship, Article 19 is also a subspecies of Article 14, which is said to be the genus of
Yours, which article will it be?
14 and 19(1)(g).
19(1)(g). Okay.
Then paragraph 25 that may bear some relevance, Your Lordship. Candidates participating in a recruitment process have legitimate expectation that the process of selection will be fair and non-arbitrary. The basis of the doctrine of legitimate expectation in public law is founded on the principles of fairness and non-arbitrariness in government dealings with individuals. It recognizes that the public authority's promise of past conduct will give rise to a legitimate expectation. The doctrine is premised on the notion that public authorities, while performing their public duties, ought to honor their promises or past practices. The legitimacy of an expectation can be inferred if it is rooted in law, custom, or established procedure. Here they had already announced in the advertisement that this is going to be the eligibility criteria. I had participated and then they have changed. So the findings, Your Lordship, the conclusions are at paragraph number 65. We therefore answer the reference in the following terms. 65.1, the recruitment process
Yes.
we therefore answer the reference in the following terms. The recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified in the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rules so permit, or the advertisement which is not contrary to the extent rules so permit. Even if such a change is permissible under the extent rules of the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Here, Your Lordship, apart from making a bold statement in the affidavit saying that this has been done in public interest, how increasing the tender capacity, the eligibility criteria by 30, mainly 37 lakhs, because a person was the person is otherwise required to show capacity of having done work up to 2 crores, 2 crores 3 lakhs. So they have increased 2 crores 40. So this appears to be apparently an arbitrary exercise of power, because there is no justification what this additional 37 lakhs is going to achieve. So my submission is that on both grounds, on the ground of arbitrariness as well as fair play in such settlement of public losses, this corrigendum needs to be set aside, Your Lordship. If they desire, let them conclude the tender process as per the originally issued eligibility criteria.
So that is only with State Prakash and Dayaram.
Yes.
What about the other two?
I'm also relying on Mirror Development Authority, Your Lordship, to show that this eligibility criteria is tailor-made to favor somebody. It has no paragraph 26, 27, 28, and 29.
And the other one, that data.
Data associates, Your Lordship, there is a very important line in paragraph number 4, which says that fairness demands that the authority should have notified in the tender notice itself the procedure which they propose to adopt while accepting the tender. And here they have, after notifying it, they have changed.
That is in
Paragraph number 4, Your Lordship. It is at page number 56, the first line at the top of the page.
Yeah. But advertisement was issued on 13/2/2024, madam. Well,
Yes.
last date was fixed for 10/3/2025. And 10/3/25, madam, corrigendum was issued that it will be extended, the time of period of filing that was extended to 23/2025.
23/3/25.
2025. And in 14 pilot, there is a uploaded that eligibility criteria, modifying the eligibility criteria. And the petitioner have not
Corrigendum is dated?
dated 10/3/2025.
No, page 33.
Page 33, man.
That is the corrigendum increasing.
Yeah.
Page 33, man.
Yes, so what do you want to say?
But this was done 7 days prior to the last date of fixing the.
Whatever.
It was-
That is all right, don't you
And-
know that.
And thereafter, my lord, on 14th, my lord, the eligibility criteria, new eligibility criteria was fixed. my lord. And the new eligibility criteria
So
was
the corrigendum was issued on 10/3,
10/3/25.
10/3/25. And
We are extending that particular tender to.
and the new eligibility,
It will come later, my lord. It has been extended to that tender last day submission extended to 23/2025.
and eligibility criteria was made when?
Eligibility criteria on 14th March 2025, my lord.
14 March.
14 March 2025.
Now, that is at page,
That is at page, that is at page 42.
yes. So what do you want to say?
Well, on 14 March 2023, the eligibility criteria has come in, my lord. So he has already had a 7 days time to 23/22 to file the tender.
Okay.
So what is the eligible? There is some modification in the eligibility criteria. There is some changes in the eligibility criteria. What will turn to page now 42. What is the eligibility criteria of the new eligibility?
40?
42.
Yeah.
The bidder must have experienced of executing the completing the at least one supply order of the wooden decks and bench. This is regarding decks and bench specifically for decks and bench, which is iron and steel frame of the government of BTC in the education department BTC. During the period specified 2022, 23, 23, 24, 25, 26 for the voted not less than 2 crore 40 lakhs. Joint venture with a farm enterprise shall not be accepted for the execution of the. This criteria has come in, madam. This criteria has come in to strengthen the supply order and to get the best of the quality of the material. This is the regarding supply order to the student.
So the earlier
No.
condition that was
Other
there.
condition was there, madam.
So
but-
what is the major difference between that and this?
No, please, we have to supply similar deck, which is a supply of decks and bench. And decks and bench, the similar decks and bench.
Mr. Council, this is like this. You see, the issue is this. Earlier, the requirement was around 2 crores. The tenderer was required to have experience of having supplied a similar material or article to the value of around 2 crores. Now you have raised that amount from 2 crores to 2.4 crores. What is the reason for raising it to another 40 crore, 40 lakh?
Lordship, the earlier clause, my lord, Lordship find it is number 23.
Yes, I know
The
that.
bidder should have experienced at least one single word
Correct,
of similar nature, government supply, including
Correct.
government supply.
correct.
There is not
Correct.
specifically like decks and bench. Here is this, it is, they have strengthened the condition.
You see, the article to be supplied in both is the same. Is it different?
No, this
The article to be supplied as per the NIT of
is
13 to
decks
25.
and bench.
It's
Now,
the same thing.
now another thing has come in the new.
So BTC is not government. BTC is what? So what is to be supplied to a union territory and what is to be supplied to a sixth schedule area and what is to be supplied to a state will have to be what? Will have to be different.
Well, they are the same manner.
The same
And
thing.
certain clause has been there. Yes,
No,
That
so what is the?
financial
what-
year also here.
Mr. Council, there's no point just going round and round. The issue is this. What is the object for raising the experience criteria from 2 crores to 2.4 crores?
Thing is that, my lord,
What is
one
the difference basically? Only besides money, what is the difference?
because financial.
What is this? How do you differentiate that do you say that a person with a 2 crore experience cannot do a 6 crore project?
Now it is, now the condition has become specific. The decks and bench, whether wooden decks and bench here supplied earlier or iron decks here supplied the BTC. Because the requirement was decks and bench for the students of BPT. Now it has become more specific and also the financial year. These are to be taken up.
You see, let us see whether the earlier advertisement, what was to be supplied.
Page number 23 with the earlier.
Page number 23, let us see. Page number 23 is, no, it doesn't start from 23.
Page 23 itself.
Starts from page 16.
16, it starts at page 16.
That is the first notice.
This is the first notice.
So please read that.
Procurement of
Out here also, what is to be supplied is desks
Yes,
and
yes,
benches.
decks and bench.
Now, what was required in the tender? It says that you should have 34%.
Yes, page number 23. That is the eligibility criteria.
It's a council. You see, the page number is already there. The issue is this. The tenderers are supposed to supply benches, desk and benches. The experience required of the tenderers is that he should have had supplied an order of 34% of what? Similar nature. So desk and benches was the experience required in the earlier tender. In the corrigendum, instead of saying similar nature, they said desk and benches. Same thing. What's the difference? It's all desk and benches anyway.
That may not be like, or government supply, public government supply, any other.
Government supply, now this BTC who has issued this tender, this director, Panchayat and Rural
Panchayat.
Development BTC, this is not government supply.
Yes, it's a government supply.
Then,
Now it has
now you
come
wanted that it should have been supplied specifically to BTC only.
specifically tax and bench to the BTC.
What is the logic?
Because
It has to be, what is the,
the tax and bench, man, tax and bench, they will supply, the person who has supplied the tax and bench.
it's like saying this. It's like saying, it's like the High Court. Or it's like the district court saying, we want files to be supplied, file covers to be supplied. And they should have experience of 50% of having past experience, 50% of 1 crore. Later on, district court is modifying their thing, their tender by saying that, no, we don't want the supplies to be to High Court. It should be specifically, should have been supplied earlier to district court. What is the difference? What is the object sought to be achieved?
Public sought to be cheap, my lord, that the goods they will supply, they have an experience of supplying the tax and bench to the BTC, and they will get the best of quality of the tax and bench to the use by the students. And
Okay, so it just because they have
these are the-
supplied to the state government or earlier does not count.
but still, he may have supplied it, my lord, the BTC wants it that he has
It has
supplied
to be
it.
supplied to the BTC only.
That is the condition, my lord, made by the.
Okay,
and it's-
very
it's-
good.
And whether it's, lots will only taste on whether the authority has the right to change it and the terms and
No, no,
conditions,
you've got the right to change, but it should be reasonable.
and whether it's.
It cannot be unreasonable.
No, it cannot be, my lord. Whether it is arbitrary or it's nullified or it's violates Article 14 and 16, my lord. That lordship will examine, my lord. Because it doesn't, he has the opportunity, he came to know it, no, it was already uploaded on 14/3.
It's,
7 days
it's,
was.
it's like saying the tender notice has said that it should have experience of supplying to the PWD department earlier. Later on, you make a corrigendum saying that no, it should have the experience of supplying only to the SDO's office in the PWD, not to the secretariat or or to the chief engineer's office. The BTC, part of the government, it is a 6th schedule area maybe, but it is part of the government. State, if they can supply to the state government, why can't they supply to a BTC?
But,
It's like saying, if they have got experience of supplying to the government of India, that is not accepted, but they have to have experience of supplying to the state government. What is the logic? I don't know.
But the authorities will have the right to set up their own condition, my lord.
Not in the manner that we are trying to do. And what is the logic for having the value, the past experience value, enhanced to 2.4 crores from 2 crores? Not even from 2.03 crores to 2.4 crores.
This is regarding their ensuring that supply comes from a person, reputed person, get the best of quality of the material, my lord, so that it doesn't come to later on, these materials are not found to be.
Okay.
And in this regard, my lord, regarding conditions is set up by the authority itself, my lord.
So your case is that, so that they have the best quality
Material
and
the best of person supplying the material.
best of persons supplying,
Because these are the funds,
best of persons supplying, and what else?
because these are expenditure of the public
And
money.
they've got the,
public
and
interest.
they have got the financial
Financial strength.
capacity, financial capacity.
Because they are, later on, it has been added, 2023 to 2025, they should have the financial strength.
I should say, okay.
And these are public money that is spending by the authority for the student, manner. And if there is not violation of any Article 14 or 16, because it will be applicable to all across the board, whoever is participating there. Not for him or any other person participating will have the same criteria.
He had participated, he has
Yes,
submitted
participated.
on the last date of submission of bid, you change the criteria.
No, in the last, not in the last, there are 7 days before. Man. It is on 14/3, then he can file it up to 23. There are 7 days.
You
prior.
changed, you extended the date.
Yes, extended the date, then. In this case, my lord, I am relying on only 2 cases, my lord. Michigan rubber, paragraph number 35.
Give me.
paragraph number 35, I have highlighted it,
Yes, and
the highlight portion, as noted in various decisions of the government and their undertaking, must have the free hand in setting the setting the terms of the tender, and only if it is arbitrary, discriminatory, malafide, or actually actuated by bias, the court will or court only if the court would interfere, the court cannot interfere with the terms and conditions prescribed in by the government because it feels that some other terms would have been fair, otherwise logical. Terms and condition of the person who is issuing the tender, it's up to him there. And secondly, the next case, paragraph
but
12.
you've got to justify also. You see, when you make some term, it has been acted upon, you suddenly change it. You've got to justify the change of the term.
Suddenly means all these persons are getting 7 days time.
It is he has got the eligibility criteria of 2.03 crore. Why you have
We are
to suddenly
strengthening
change
that
it to
particular
2.4?
condition. We are strengthening the particular conditions, because to get the best of quality.
Best of
And
quality. Instead of that, why don't you ask for the tenderer to have the bank statement, bank statement of 6 crores, the entire supply? That'll be much better. That'll be 100% guarantee that he has got the
Right, okay.
capacity.
But it's
2.4, the amount to be supplied is 6 crores, around 6 crores. 6 crores. And if you want the person who is 100% financially sound, you ask for a person who's got 6 crores in his bank. Why ask for 2.4?
they are check with the authority of the decision that they
Has
decide
to
the
be
criteria.
justified. There has to be some justification for change of the, because earlier it was 2.03. Now why have you changed it to 2.4? Anyway,
Second case, paragraph on the similar line, paragraph number 12. It's only actually on the similar line, paragraph number 12. Because the authority should have an independent hand setting the terms and conditions, unless it is arbitrary, legal and malafide, who will not interfere.
Yes, anything? No. Okay, right. Heard Mr. KP Pathak, learned counsel for the petitioner, as well as Mr. S. Bora, the learned standing counsel, BTC. The petitioner is aggrieved with the sudden change in the terms and conditions of the NIT by way of a corrigendum made on the last day of submission of the bids. The petitioner's case is that the respondents had issued NIT dated 13/2/2025 for procurement of desks and benches for distribution in the various schools under the BTC for an amount not exceeding rupees 6 crore. Issued by the Director, Panchayat and Rural Development, BTC. BTC is a 6th schedule area, correct? The last date of submission of bids in terms of the NIT dated 13/2/2025 was 10/3/2025. Next part. The respondents thereafter. No, wait, before that. Clause 5 of the eligibility criteria of the NIT required the bidder to have the experience of executing at least one single work order of similar nature / government supply order of minimum 34% of the tender value and the annual financial turnover minimum 67% of the tender value. Bracket. In all cases of civil engineering, full stop, norm, no, civil engineering norm, no full stop, / government supply, bracket close, in 1 year during the last 5 years, comma, updated to the present price level. Next. The respondents thereafter issued a corrigendum dated 10/3/2025, comma, that is on the last day of submission of tenders in terms of the NIT dated 13/2/2025, wherein the wherein clause 5 of the eligibility criteria.
What, 10/3, first extended thing, date of submission.
Wait. Wherein the last date of extension of the bids pursuant to the NIT dated 10/13/2025 was extended up to 23/3/2025. Correct?
23.
Thereafter, the respondents issued what is it? What did they issue?
They issued another corrigendum on.
Where is, it doesn't say corrigendum.
It's a, Lordship will see page number 34.
It's part of page 34.
Yes, it starts at page 34. This is what was uploaded on the portal. It says a
Issued a corrigendum dated
published
dated
14/3/2020. Down below.
No,
down
no.
below is 14/3.
on top it
14.
says 19/3.
That is the date on which I obtained a copy.
Okay.
Down below
14/3/2025. 14/3/2025. Wherein clause 5 of the NIT dated, clause 5 of the eligibility criteria of the NIT was altered. First up, as per the new clause 5 of the corrigendum dated 14/3/2025, the bidder must have experience of executing and completing at least one supply order of wooden desks and benches with iron and steel frame. Iron and steel frames. Of government or BTC in education department. For an amount not less than rupees 2.4 crores. Question. Only one thing, Mr. Pathak, out here they want with iron and steel frame.
Yes, sir.
In the earlier, there is no iron and steel frame.
There is nothing in the earlier.
Then
If they wanted iron and steel frames, they can perhaps, they could have included in the eligibility criteria. If this is, nowadays, there are actually all benches, there are no wooden benches anyway. Every bench comes with iron frame. The specific problem which the petitioner is facing is regarding the financial aspect. Because otherwise the benches that they are procuring, they can always refuse to accept it. If they say that the benches are not up to the standards that they want, they can always refuse to accept such benches.
Full stop. The petitioner's counsel submits that the change in the financial capacity, financial experience,
Yes.
the change in the change in the financial experience required of a bidder in terms of clause 5 of the NIT vis-a-vis clause 5 of the corrigendum,
Along with a specific that they have limited past experience only to the BTC.
restricting the experience of supply only to the BTC. Is arbitrary and liable to be set aside. And liable to set aside. Full stop. He submits that the rules of the game cannot be changed after the game has been played, in as much as the petitioner had the past financial experience of supply of similar material in terms of clause 5 of the NIP, wherein a tenderer was to have had the experience of a supply order of a minimum 34% of the tender value. So you have supplied for 34% earlier.
Yes, I have experience.
You do not have for above that.
I meet that criteria, I do not notice it.
He submits that 34% of 6 crores amounts to rupees 2,03,99,660. The raising of the raising of the minimum supply order for a bidder to be qualified to participate in terms of the corrigendum to 2.4 crores is without any objective criteria. No reasons have been given by the state respondents as to why the past experience criteria of having supplied similar materials of rupees 2,03,99,660 has been raised to rupees 2.4 crore. He accordingly submits that the raising of the past experience, financial past experience, raising of the past experience of having supplied similar materials to rupees amounting to rupees 2.4 crore, being without any nexus to the supply to be made, the same should be set aside. He also submits that he also submits that as per the NIT dated 13/2/2025, a bidder was to have the past experience of supplying similar material to the government. However, by the corrigendum, the supply of materials, similar materials, to the government, to the state government is no longer valid. And a bidder is required to have the experience of supplying similar materials only to the BTC, which has uh, to which the respondents have given no reasons, for which the respondents have given no reason. When the BTC is a part of the government, when the BTC is also the government, the restriction on doing away with supplies made to the state government is arbitrary and has to be set aside. Next up. In support of his submissions that clause 5 of the corrigendum dated 14/3/25 should be set aside. He has relied upon the judgments of the all the judgments are not required.
Only perhaps, Nandairam Shetty,
He relies upon the judgments of the Supreme Court in the case of Dayaram Shetty versus International Airport Authority. I reported in 1979 3 SCC 489, Tej Prakash Pathak and others versus Rajasthan High Court and others reported in 2025 2 SCC 1, Meerut Development Authority versus Association of Management Studies and another 2009 6 SCC 171. And in the case of Datta Associates Private Limited versus Indo Mercantiles Private Limited and others, 1997 1 SCC 53. Next paragraph. Mr. S. Bora, the learned standing counsel BTC. On the other hand, submits that there is no arbitrariness in the change of clause 5 of the NIT by clause 5 of the original. He also submits that the change in the past experience of a bidder had been made after the last date of extension of submission of bids had been allowed, had been made. And as such, the petitioner had the opportunity to submit his bid in terms of the change in clause 5 of the NIP. So we also submit that the change in the past experience of the bidders has been made to enable the respondent BTC to get the best quantity. Best quantity or best quality? Best quality of benches and chairs for distribution to the various schools. I wonder how, made of what? Teak wood or what? What do you want? Rosewood, teak wood? I think we'll have to go and check your benches in school.
There are multiple complaints, but
We have seen the government supplies everywhere. And especially in the 6 schedule areas. Mizoram has got 3 6 schedule areas. And there's nothing there.
past experience was that benches are not were supplied necessarily, that it can be used for many.
Where will you get the wood? Really, what good wood do you have here?
Wood we have, but there are
What wood? Quality of wood is very important.
now basically.
Quality of wood, age of wood, very important.
Now basically it will be what you call that. Wood with a compression now.
Compressed wood.
Now,
Oh, compressed wood too will go.
that
Within
also
a
will
short
be-
time, it will go.
that they have to be framed by lot.
No. Compressed wood will go. Compressed wood has got no life. Have you tried compressed wood in your furniture in your house? After 3 years, 4 years, they're all, cockeyed and whatnot. They're not straight. And these are for benches and chairs in schools.
That's why
Moisture. And with the amount of moisture that is there in the northeast, it will not last.
that iron frame have to be there.
It can be, I can understand iron chairs and all. I mean stainless steel chairs and all. They will last. Only thing is that you have got to paint them once in a while. You don't want best quality. I don't believe. Okay, right. What have I said? First up, further, the raising of the financial capacity, financial past experience of supply of the items from 2.04 crores to 2.4 crores is to ensure that the best person supplies the items having the required financial capacity. He submits that in terms of the judgments of the Supreme Court in the case of Michigan Rubber India Limited versus State of Karnataka and others, 2012, 8 SCC 216. And in the case of Directorate of Education and others, Educom Datamatics Limited and others, the government and their undertakings must be given a free hand in setting the terms and conditions of a tender. And the courts should not interfere with the same because it feels that some other terms would have been better or wiser. Correct. He also submits first of all, further. The courts should not interfere with administrative policy decisions and should not strike down the terms of a tender prescribed by the government unless it is arbitrary, discriminatory, or maleficent. According to submits that the writ petition should be dismissed. I have heard the learned counsel for the party. Hearing concluded, judgment reserved.
Two things, Your Lordship. The first sentence, Your Lordship, has reported that we are challenging the corrigendum that is 10/3/2025. We are challenging the corrigendum that is 14/3/2025.
At the beginning,
First sentence.
challenging the corrigendum dated 14,325.
And Lordship, one more thing. Like in the first original tender also, they have a right to reject materials supplied if they are of poor quality and the work.
Actually, one thing you're right, huh? One thing you're right. I've heard the learned counsel for the parties. To decide the issue raised by the petitioner, it would be best for all if clause 5 of the NIT dated so and the corrigendum dated so is reproduced herein below. NB is reproduced herein. Is reproduced. Is reproduced. Then you write clause 5 of the NIT dated 13 to 2025. That is at page 23. And clause 5 of the corrigendum dated 14/3/2025. That's at page 42. Just take that. There is 38.
This IA has been filed for impeding the applicant as a petitioner. Because by the present company, the applicant company has taken over the liabilities of the petition. So these applicants may be added as a petition number 3 in this petition.
Mr.
And
Hoc, learned counsel for the applicant says that the applicant may be pleaded as lead petitioner number 3. Mr.
I'm sure for the response numbers 5 and 6, original writ petition.
M. Sharma, learned counsel for the writ petitioner, submits that he has got no objection to the application being allowed. Next, in view of the above, in view of the consent of the parties, who is the applicant? Name?
ATC Telecom Infrastructure, that is based to in I.
The ATC Telecom Infrastructure Private Limited, page 29. Is impeded as writ petition number 3. Are you filing anything? No, nothing. Applicant should submit a corrected copy of the post title to the registry within 3 days. I is accordingly allowed and disposed of. Then you write in the main case, in view of the order dated today, passed in ISC number 912 of 2020. 2020?
Just
2020.
2020.
What has happened? Why suddenly?
Notice of not issued. There was some.
2020. So ATC impeded as the petition number 3. Okay, the minute to make it. Yes, what to do?
Notice has been issued in this petition.
So,
Parties have appeared. Parties have appeared.
this is a matter after 4 weeks. Right.
Typing item 27.
It was here, Lordship.
PWD.
Home Department, Lordship. PWD is the executive authority, only executes, Lordship.
Yes, what is to be done here?
My lord, initially not been released. Now, my lord, from department to department, issues are there. My lord, may I make one submission? My lord, now Mr. Prigogo is the additional AG as well. If your lordship, this is the last of the 11th for 2025. He has already appeared. Additional AG is appearing for the government, my lord.
Correct.
The freezes can be ironed out. Lordship, any freezes in between the interdepartment, it can be ironed out.
That can be done, Lordship. Here, Lordship, I am appearing for the final only if I can get the proposal because as per my knowledge, Lordship.
Proposal is to be given by the PWD.
No,
Correct.
Lordship, by the Home Department.
Home Department.
PWD is only executing it, Lordship. So they are they're doing the work, but the work was allotted by the home department, so I think the payment has.
I don't know, I do not know how it's done, but you see, in some other states, when the you see, the PWD is usually given the money.
Yes,
It supervises and given the money and everything goes,
and then the work is completed and.
then they hand it over. That's
Yes,
all.
sir. So
So actually, I don't think Home Department has got any role to play.
it is in the affidavit.
Because the money will come to the home will then have to give it to the supervising authority.
Yes, Lordship, and in the affidavit filed by the home department, they have only said that they have forwarded the proposal, Lordship.
So they forwarded.
Yes, this is.
So the money is with them,
Yes,
Home
Lordship,
Department.
Yes. So Lordship may grant me a short date, Lordship. I'll coordinate with the home department as well and we'll seek for the information regarding, because now the new financial year has started. So already I think a budget is already provided to them. So Lordship may grant us 10 days time. In the meantime, we'll coordinate with the respected. Okay.
Malak, I spoke to the concerned officer. They informed us that in the last financial year, ultimately because of some delay on the part of the Human Rights Commission in raising the bill, it could not be reversed. But they are in the
Human Rights Commission has got no role to play in raising the bill.
the bill has to be submitted by them.
No? Why?
The amount will come from
The building was constructed by whom?
the Human Rights Commission.
No, please. You don't know the case.
No, but we have, for the Home Department, we have filed the affidavit. Ultimately.
No, you see, Human Rights Commission has got no role to play. The Home Department was the one who constructed it. The cost for the project is given to the Human Rights, is given to the Home Department.
So the PWD department was constructed.
Because PW department was the supervising authority.
Yes. And the amount which was already allocated, the earmarked amount, that has been already given.
Given to whom?
Given to the contractor, he has received the amount. Now the dispute here is as regard the additional amount. That was actually not approved earlier.
Naturally, that is why there is provision
Yes.
for revision,
Logic.
revised cost escalation, all that is there.
No, this is for the additional amount.
Okay.
So the additional amount that already the proposal was sent in the last financial year to the finance department. They were awaiting the response on last visit. We applied before the honorable court, and the finance department, my learned friend took time that, so what is the status they will apply. So in the meantime, I have also spoken to my officer in the Home Department. They said that in the last financial year it could not be released because of some delay in submission of the bill. And now they are in the process for taking the fresh one of the.
Who is in the process?
The Home Department.
That is why Human Rights has got no role to play.
No, they said that the sanction has to be given by the Home Department, but some formality has to be done by the commission. That is what they said. Ultimately, they are going for the ultimate thing is the Home Department is under process, and they are in the process of having the fresh sanction for this in this financial year, because the last financial year it could not be.
Page 28, name of the department, Home and Political Department.
Yes.
Page 28 of the.
Huh?
Yes.
Page 28 of the report.
Yes.
Name of department scheme, Home and Political Department.
It is clear that Home Department, nothing to do with human rights. Human rights is just a commission. That's all. So Home Department has to initiate the process. So when are you going to give the proposal?
They said that they are in the process.
They are in the process will not do. You were in the process last year also. You are in the process for 24, 25. That year is gone, finished.
In fact, it was sent to the finance because of some.
This is the thing is this. The only thing that is required now is a change of date. You can submit the same thing again because you are not going to change the contents. The contents of the proposal to be made by you is going to be exactly ditto, except the date on the top and the forwarding letter, the signature, and maybe the memo number of the letter. That's all. The contents or the annexures to that is going to be exactly the same. So when can you give? That should not take long. There's no change, no rocket science is required. Uh, Because what is happening is the finance, they want to take instructions as to what is going to, when the sanction can be made. But that cannot be done unless you submit your proposal by changing a few dates here and there. That's all.
Malad may keep the matter on 14th or 15th, I'll write the another book. By this time, they saying.
Okay, right. Mr. J. Patwari, learn cost for the petitioner, submits that. The petitioner has not been given the additional cost for the construction of the Assam State Human Rights Building. Mr. A. Chaliha, learned counsel for the Finance Department, submits that. No proposal has been received for the financial year 2005-6.
I'm not aware, but they have sent.
That is what he's saying.
25, 26 in this year, it is not, it is under process.
You have to give. Now that we cannot go to back into the future. Back to the future, no? That was that? That movie, Back to the Future. That's what.
3 months.
Anyway, what do I say? For the financial year 2005-2006. 25-26. For with regard to the claim of the petitioner. In as much as sanction could not be provided during the year 2024-25. Mr. Dinath, counsel for the PWD submits that he will obtain instructions as to the proposal to be submitted to the finance department for the contract, for payment of the contractual dues payable to the petition. This court is of the view that the proposal that had been initially submitted by the PWD to the finance department during the year 2024-2025 and the proposal to be submitted now cannot have major changes, as the only issue would pertain to change of dates. Accordingly, the instructions required should be provided by Mr. Dinath on the next date. This is the matter on
Let it be on 14th or 15th.
15.
I know that recorded him as PW's home and political.
Kindly see,
Home and political. Okay, home and political.
home department has sent.
Home department, home and political department,
PWD.
not PWD.
Deep level.
I will respond.
Milord, your lordship may see the order dated 21/10/2020.
2110. Yes.
21/10/2020. Your lordship will find in paragraph 4. The petitioner is allowed to strike out the respondent number 1 being the presiding officer level 2. And its place carry the Union of India through the Ministry of Labor Government. Now, my lord, so far Union of India has got no room to play. So, my lord, it's not required to be arranged as respondent number 1.
But the order is there.
What is there?
What to
my
do?
lord, since it's not a necessary party at all. So therefore, my lord, your lordship may fix it for hearing. The record has already come.
And it is a dispute between Mila management and the Sangha representing the workman Mila. And I.
And
Sangha representing the workman concern. It is industrial dispute Mila. So Union of India has no.
with regard to 50%.
No, my lord, that foods is not in question here.
Not a question. What's the question here?
The question is this, this person was the workman. Now the allegation is this, he used to collect 30 rupees per month from all the workers who are resident of the garden. Now he did not deposit in the.
30 rupees for what?
Labor fund.
The 30
For payment of electricity.
for payment of electricity. Okay.
Well, now, he did not deposit the amount in the record of the management. Ultimately, my lord, the charge was framed against him. And the disciplinary proceeding was proceeded, he was found guilty and he was
Terminated. So he's been reinstated.
Um,
Yes, award is in.
Award is in his favor
yes, right.
with 50% back wages.
Yes, right.
So you're challenging that.
Yes, we have challenged.
That's what I think.
Right.
So
But since the record is available,
record has come, but I pray for fixing a date of hearing, madam, since it is the 2020 matter.
Give me a date. You have decided.
anything. In the month of June, in the middle of June.
Yes.
10.
Yes, then.
On the prayer, the parties list the matter on 10 before.
Obliged.
Yeah, I'm appearing for respondent number 2, my lord. Lord, I seek for some accommodation, my lord. A small accommodation, my lord, at least for 1 week, my lord.
Has it been paid? The balance?
A portion has been paid, my lord.
I know 83 lakhs have been paid.
4 lakhs, 13,000.
83.
Yes, what should we 3 lakhs is.
Balance, my lord, because there is some changes in the post of MD, my lord. So, just 1 week time I am seeking, my lord. I'll release the entire payment.
You give it by Thursday. Next Thursday. We'll fix it for next Thursday.
Next Friday, my lord.
No, Thursday you give. What is this? You have been delaying the matter. You said it'll be paid within 1 week.
Yes.
You tell your boss to pay. Okay, otherwise we might have to pass some strict orders.
My lord, we'll fix it, my lord, we'll fix it on 8.
Right, Mr.
8 acre, my lord.
A. Dekha appearing for the response number 3. Is granted, submits that the entire payment will be paid to the petitioner by 8th. List the matter on 8th.
Last occasion, my lord, they have paid for time. Today,
What to do?
last date may be fixed, another date may be fixed, so that they can appear. On the last occasion said that council was not well. That is why I paid for time.
Okay, right. No one appears for the respondent. In the interest of justice, list the matter. Give a date.
Right.
Before my senior colleague starts lordship, I'd like to submit that the concerned advocate as Barrack and as Roy. They also went for Arunachal Pradesh lordship, so let me kept all of them must pay.
We also had a talk with the council, my lord.
Today morning they came to know.
But my difficulty is something different. That after filing of this writ petition yesterday, after receiving the copy, my lord, the officials went to the outlet to take over the charge. That's the difficulties, my lord. And therefore, my lord was very kind enough to allow the matter to be listed today itself. But the impugn termination, my lord, was issued when the arbitration proceeding is commenced. And also a stay order operating, my lord, of the commercial division appellate forum of this honorable court. The impugn order.
No, what is your case? Just tell me.
No, my lord. My lord, we are the dealer of a petrol pump in 2008 under the Numoliga refinery, which was taken over, my lord, by the BPCL. And thereafter, a agreement was entered in 2023. on 28th of
What
March.
was taken over?
Now, what happened, my lord?
No, what was taken over?
The petrol pump, the position of the petrol pump.
When? 23,
No. Agreement was entered in 23
between?
between BPCL and this petitioner, my lord.
Petitioner.
Domain entered here.
Huh.
Now thereafter, my lord.
But the petrol pump was running since 2008.
Eight.
Between the
Numoligar and this.
Numaligarh is under BPCL?
No,
No.
they take over, my lord.
Huh?
Numoligar refinery was
Taken over by BPCL?
Yes,
Ah.
correct, correct. Then after they take over, my lord, a new agreement was.
So the earlier agreement was between you and Oil India or what?
No, Numoligar.
Numaligarh is under what? Numaligarh refinery.
This is a company.
It's a separate company altogether.
Separate company.
Oh, it's not Oil
BPCL
India or anything.
No. BPCL is also public sector undertaking. Now, what happened, my lord? They have inspected and they have taken over some pulsar. It is the inner parts of the dispensing unit on 2/8/2023. Before that, on 2/8/2023 itself, the report says that the seal was intact.
Seal of?
Seal of the DU, that is the dispensing unit.
Ah.
That was fine, that was intact. It was in the report. Now they take over the inner parts. It was tested in the lab of a third-party vendor who in fact manufactured this dispensing unit and also carried out the maintenance work. Is appointed by the BPCL. Now they tested in their lab at Bangalore and they found some malpractice over that inner parts. Now it was inspected by the legal metrology department of the state government. The legal metrology department says in a certificate that all the seal seemed to be intact and there was no question of any malfunction. That was the report of the legal metrology. Thereafter, they issued a so-called notice on 21st January of 2023.
21st January.
2023. We replied the so-called notice on 5th of February 2023.
Yes.
Then, my lord, apprehending because they issued the so-called notice for termination. Of that so-called notice come termination notice. That 22nd of January 2023. So we approved Section 9 application before the
Section 9 of?
Arbitration and Conciliation Act, my lord, because there is the arbitration clause in the agreement. Clause 19, my lord. So in pursuance of that clause, my lord, we approach the commercial court because nowadays, my lord,
So the arbitration clause is at clause 19 of the agreement.
yes. And we invoke the Section 9 application before the commercial court, that is the civil judge senior division at Kamrup Metro. And on 3rd of July, my lord, to 24, an interim order was passed by the London Commercial Court, restraining them from taking any courtship action, including the termination of agreement dated 28/3/2024. 23. So then,
Then this
then the
section
notice has been
says,
issued, my lord.
huh?
Then the notice has been issued. This is as per the
So section 9.
Section 9 interim order. Then notice
No,
was
but
issued.
why you have made a reply already?
Yes,
So they have not taken a decision on the show cause.
yes, because the interim order was passed by the commercial court. And
Then you went to the commercial court.
yes, sir.
They should have been allowed to take a decision.
No, that I will come to that in a few minutes now. Then the notice was issued under Section 9 application. Then they did not choose to contest the case. They received the notice. Then finally, on 7th of September 2024, the interim order was made absolute against the BPCL. And here is the important point, my lord, that the London Commercial Court also give us a liberty to proceed with the arbitration procedure. Then we issued a letter for appointment in arbitrator. And we filed an application under Section 11(6) before this honorable court for appointment of an arbitrator. They participated in the hearing, is pending. Now, meanwhile, what happened, why they now terminated, taking an advantage of a stay order, they preferred an appeal against the injunction order before the appellate court, learned additional district judge. Now, learned additional district judge passed an expertise stay order, nullifying the entire this injunction order. Now, what difficulty was at that time that this stay order will nullify the Section 9 application. So they are now
Which stay order?
this appellate court.
Okay, appellate court stay, no, appellate court had set aside the order.
No, only stay.
Understood.
Appeal was preferred and expertise stay was granted on 5th of December 2024. Now, therefore, we preferred a commercial.
5th of December.
December.
5th of December 24, appellate court stated.
Stay of the injunction order.
Yes.
Thereafter, what happened, my lord? Our High Court has issued a notification in 2023 constituting a commercial appellate division. Though you see, without there's a my lord, there's a jurisdictional some lapses are there. But since there is an appellate forum before the High Court, so we preferred an appeal against the order of the stay of 5th December 2024. It was taken up by the division bench of the Supreme Court, and on 3rd of February, 13/2/2025, a stay was granted of the order dated 5th of December 2020. That is the
stay granted when?
13/2/25 by the Commercial Appellate Division, fixing the date on 27/2/2025. Because the Commercial Division raised the question of the maintainability of the jurisdiction of the Commercial Division itself. So therefore, the
Commercial division of that Sessions Court.
District Court. Before this court. There are the commercial court says, my lord, that there should be a commercial court, there should be a appellate court, and in original jurisdiction which the High Court has, there would be a commercial appellate division. We have no original jurisdiction. So there would be not an appellate jurisdiction here at the High Court. But the Honorable Chief Justice of the Honorable High Court, by notification, constituted this bench. So that issue was raised. We also supported that itself this commercial appellate division having no jurisdiction. Because there cannot be a 3-4, cannot be a second appeal in the commercial court.
So this High Court did
So
not have.
what happened, my lord? On 13/2/2020.
But you still came to the High Court.
Yeah. Now.
But the High Court does not, cannot have that. It could not, does not have the jurisdiction.
Yes, but we have no other option because the notification was there by the Honorable Chief Justice. And
you could have gone to the Supreme Court.
No, I cannot bypass this division. Commercial division, this commercial division appellate forum, we cannot bypass, my lord, since it is constituted by a notification by Honorable Chief Justice. So we are compelled to come here. Otherwise, we have to wait to the Supreme Court. Now, what happened, my lord? On 13/2, we are protected from that stay order. 5/12 stay order.
512 is the, no, 512 is against you.
Yes, that order was stayed by the.
On 13/2.
On 13/2. Now, the next date, till the next date of district, it was the order.
That is 27/2.
27. Now, on 27/2, the matter was heard by the division bench. The jurisdictional issue. Now, the order was reserved. Now, therefore, once the order was reserved, my lord may appreciate that there would be no question of the extension of the interim order again. The order was reserved by the Honorable Division Bench. Now, by taking that advantage, they said in the termination letter, taking that advantage, the High Court has not expressly extended the interim order. On 12/4/2024, when the judgment is reserved, they terminated the dealership.
No, judgment reserved when? On 27/2.
True. And they issued till the judgment was not pronounced. The judgment was pronounced on 23/4/24/25.
23/4/25.
Right. Now, meanwhile,
taking the, they say in the termination letter that since the High Court on 27/2/2025 did not expressly extend the interim order, so they are not prohibited from taking the decision of termination. It is against the larger than decision, Lordship is aware that the five judges bench of the Supreme Court says in February 24 that unless there is a judicial order of vacating the stay, it cannot be said to be, because by the lapse of the time, it cannot be said to be vacated. Paragraph 19 of the judgment. Earlier, this 6-month time, etc., Lordship is aware. So it was interfered by the larger bench, and larger bench says no. That cannot be unless there is a stay order is passed by a judicial order, it has to be vacated by a judicial order. So in spite of that, this is a public sector undertaking, my lord. This is without the fairness of administrative fairness, and this abuse the process of the judicial process. Once this arbitration proceeding has been commenced, because we have issued the notice, section 21, my lord has appreciated that once the notice has been issued, the arbitration commenced. Now, when the matter is pending before the appellate court forum, and also when the stay order is subsisting, when the judgment is not pronounced, meanwhile they terminated my dealership.
When was the termination?
12/4. You see, the council is not present today, my lord. And the final order
Now,
was
what is
passed.
this? What is this? This is a, what is this? This is a writ petition.
My lord.
Against
The
what?
Supreme Court says, my lord,
Against
against
what?
the termination order, because there is no, because we have no remedy, my lord. We have no remedy. Because against the 510, after the dismissal
No,
of
no, what has happened to their 11-6 petition?
the 11 is pending, my lord.
11-6 is pending.
They appeared in the.
No, now.
Now, if the my termination,
But then,
my lord.
so the show cause notice of 21/1/23
My lord.
has now been decided by this termination order dated 12/4/25.
Correct.
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 Actually, it appears that they should not have been any stay of the show cause notice in the first instance.
There is a stay, my lord.
They should not have been.
No, the 27 to what happened, my lord, the judgment was reserved.
No, I'm not on that.
Oh,
I'm talking about the initial stay given by the commercial court in Kamrup.
no. 512.
512. No, 512. Oh, no, what one was that? That was on
7/9.
no, 3/7/24.
The 3/7/24 culminated by 24/9/24, my lord. 3/7/24 was the first order by the Section 9 application, interim order. That was culminating in the final order.
No,
of 7/9.
3/7/24 is before the commercial court,
Right.
Kamrup, where you had asked for stay of the show cause notice.
Yes, that was stay. No, not to terminate the dealership agreement. That was our prayer. And not
But
to,
then it passed not to terminate.
Yes.
But then how could you have? That is a decision to be taken by the authorities whether it's going to terminate or not.
this the entire matter is under the arbitration clause, my lord. The entire dispute that resolved for the resolution of the arbitration. And therefore, we are involved the arbitration.
No,
clause.
the arbitration clause can always be invoked after the termination also. Doesn't have to be invoked prior to termination.
But by the problem is with us, my lord, that the termination, so for the termination of the dealership is concerned, now it is only we can challenge it under the jurisdiction of the 226 of the petition. That is a judgment of lordship is aware.
No, I'm not aware of anything. You've got to permit.
There is a three exception. There is a three exception the Honorable Supreme Court says. Number one, if it affects the fundamental right. Second is if it affects the natural justice. And if it Whirlpool and Hanslow 2003, my lord. 2003 to ACC Supreme Court. So under these first two exceptions, my lord, we are covered.
That is also discretionary.
Yeah, absolutely correct. But since the arbitration proceeding is commenced, now What they will lose. I am a woman entrepreneur. My livelihood is in the state. my lord.
The arbitration has commenced since when?
On 15/7/2023, once we issued a notice.
Why is it not completed till now?
No,
Arbitration.
they have taken time, my lord. The BPCL has taken time. We have issued the notice on 15/7/2024, long before, under section 21 of.
What has the division commercial bench said out here?
They said that they were not on merit. They expressed no, they said that without any jurisdiction, this commercial appellate division have no jurisdiction to entertain.
So if they have no power to entertain, that means the stay of the appellate court.
That was came to an end on
How
20.
how can it come to an end?
That's
That is revived again. I mean, you see, there was a commercial court of the senior civil judge.
my lord.
His stay order has been stayed by the
Appellate court.
appellate court. So the appellate court decision was challenged by you before the commercial division here.
My lord.
The commercial division court has said that we have got no
Jurisdiction, but we did not
jurisdiction
express any
so
opinion.
they have not said anything. So now their order goes automatically.
But before that, my lord.
No.
Yes.
So after they say that they've got no jurisdiction, that means that the order of the
Again,
of the first appellate court will be there.
Survive.
Will survive. So the only remedy now for you against that order is to go to Supreme Court.
Now
But I know now, because the issue with regard to whether the division bench had the jurisdiction to entertain the case was still pending here. They could not have issued the termination order. That's it.
My contention is my twofold contention. One contention, my lord, to be considered by the Honorable Court is that once the arbitration clause is commenced, arbitration proceeding is commenced as per section 21, you should not be hurried. The entire
You should not be.
hurry to terminate the dealership, etc. This is number one. And number two is that the stay order dated 13/2/2025 by the commercial appellate division of the Honorable Court, that was not vacated
That is not.
on 20.
That is what I'm saying.
12/4/2024.
That is your case.
Yeah, that is my case, my lord. So therefore, till the next date, I may be protected not to take any action, my lord.
No, it's already done.
Yes.
It's already done.
No, not done, my lord. No. Possession was not taken.
No, you see, what has happened has already happened. Now we will hear it on Monday. Because you see, the problem now is that the termination order has already been issued.
My lord. Now, if your lordship find that this order has been
And
in
you
a
see,
colorful
it has been issued on
12/4.
12/4/2025. Today is
Second of May.
2/5.
No, I just explained, my lord. We are not in delay. That was served on 19/4/2024. We have filed an IA before the commercial division because this is the matter. So we have.
Which commercial division?
Yes. So after receiving the copy, after serving because they are dated 12/4, they by WhatsApp, they have served the notice on 17/4. The hard copy was served on 19/4. We immediately came before the division bench and by an IA. Now, when we filed the IA, the matter was taken up on the 23rd of April to 25 by the division bench. On that day, the judgment has been delivered. So since the division bench says that we have no jurisdiction, so my IA was also closed. Naturally, then we challenged the 5/12 order, 24 order before the Honorable Supreme Court.
Oh, you have gone to Supreme Court?
Yes, we against 5/12 order.
What 5/12? There's no 5/12. You have not said that.
5/12/24, my lord. Appellate order. Stay order.
Okay, 5/12. Yes.
Yes. Against that 5/12 order, we went to Supreme Court.
Supreme Court when?
On 25th of April 2024.
think that was also dismissed.
No, I'm saying, and we are not saying everything in the.
So this Supreme Court, you went
Supreme Court take
against,
up the matter on
against,
30th
against that appellate order.
April. Now, on 30th April, my lord, the Supreme Court has take up the matter. And Supreme Court says, Honorable Supreme Court says that the Supreme Court, while not inclining to interfere of the order of the 5/12/24, directed the additional district judge Kamrup Metro to expedite the appeal. That was the order by the Honorable Supreme Court.
Expedite the appeal, what appeal? The next section 9.
No, section 9 only disposed of, my lord. The 5/12 is the appellate court order.
Appellate court, yes. So it told the appellate court
Yes.
to dispose of the appeal.
That was the direction by the Honorable 30th Court. Now, our problem is, my lord, that the termination order is there. We will be on the street when they take over the position. So therefore, there is no other remedy available to us unless these 226 may not.
Yeah, we'll see. That can always be changed.
On Monday, you already heard on Monday. Kindly appreciate.
Yes, because today, at the time you made your prayer in the morning, your cases had not been registered.
My case, these are registered. They're filing it today. They filed it yesterday.
No registration number has been given us. Huh?
The filing number we have got.
I remember.
Yes, sir. Filing number, yes, sir. Our only difficulties, my lord, only kindly appreciate, my lord, only difficulty is that not to take any coercive action by them.
No,
Till the
we'll
matter
see,
is
we'll
not by
see.
this honorable court.
No, we'll see. Right.
On the 9th, Lordship, I am the outstanding lawyer. So on 8th or 9th, the matter may be fixed, my lord. Monday is difficult for me also to come. Until that, there may be not to take the position, my lord.
I will not say anything. I will change. I have to go through.
On 5th or
You see, I don't. You see, the thing is that I want. If I had heard the other side, it's okay.
My lord. I understand.
Otherwise, I don't usually. You see, unless it's very clear cut, we have got to be careful also.
My lord.
And especially the entire. Anyway, that's gone. Right. But Mr.
on 5th or 6th, Lord, 8 and 9, they again have to go the same one.
That's a difficult thing.
8 and 9, let's say, they explain that they have difficult on 8 and 9. That is on Monday or Tuesday, 5th or 6th of next coming.
He's having difficulty. I don't know. I don't know. You're from where?
I'm from Pichukya.
It's okay. Right. Third, let me see. Third, Mr. Bhaskar Datta, learned senior counsel for the petitioner, assisted by Mr. F. Dekar. The petitioner has prayed for setting aside the termination of the petitioner's dealership agreement dated 8/3/23.
28. 20.
This is what is in the thing.
Typing mistake.
In your prayer at page 33.
In my mind. Yes, I can.
Typing mistake.
Yes.
Okay.
28.
Dealership agreement dated 28/3/23. By termination letter dated 12/4/2025. The petitioner's counsel submits that the petitioner has been running a petrol pump at Tingrai Gown in Sukhiya since the year 2008 on the basis of a dealership granted to the petitioner by the Numaligarh Refinery Limited. The Numaligarh Refinery Limited was What, transferred,
Transferred to BPC.
was transferred to the BPCL. On
That's we do not know, my lord.
which year? What do you mean transferred? Numalikar is still
It
here.
is taken over, my lord.
Taken
It's
over.
transferred. Sure.
Okay, was taken over by the BPCL
2012.
in the year 2012. Then what happened in 23?
23, the fresh agreement was entered in.
Whereupon a fresh agreement was entered into between the petitioner and the BPCL for running the petrol pump. In the year 2023, there was there was persistent malfunctioning in the dispensing units installed and maintained by Gilbarco, Gilbarco, Root, GVR, bracket GVR, a third party vendor appointed by the BPCL in the dispensing unit of the petrol pump. The dispensing unit was sent to the GVR.
Internal part.
The internal parts of the dispensing unit was thereafter sent to the GVR for rectification,
For testing.
for testing, wherein it was found that what was found?
Due were manipulated.
Huh?
The word is dispensing unit found to be manipulated.
Wherein it was found that the dispensing units were found to be manipulated. The petitioner's case, on the other hand, is that the legal metrology department of the government of Assam had also inspected the internal parts of the dispensing unit,
The entire dispensing unit.
had inspected the dispensing units as a whole and issued a certificate ruling out any irregularity or tampering in the dispensing unit. Next paragraph. The petitioner's counsel submits that subsequent to the above events, a show cause notice dated 21/1/23 was issued by the BPCL.
22.
22/1/23 was issued.
24 man.
Huh?
January comes, so 24.
No, show cause notice.
Show cause notice is 22/01/2024.
Paragraph 16.
You see, I have recorded it. That means at the time of a submission, you have made wrong submission. Because the next your reply is also of this. Okay, anyway. What have I said? Was the BPC to the BPC by the BPC to the petitioner, asking as to why his petrol pump. No, why should where is that page?
The paragraph 10, page 16.
No, I want the show cause.
Show cause is 203, my lord.
Show cause notice dated 22/1/24. Bracket page 203, you're right.
Then our reply. 241, page number. No, 224.
To show cause as to why his dealership agreement should not be cancelled, as there had been tampering and manipulation with the petitioner's dispensing unit. Pusta. The petitioner thereafter submitted his reply dated 5/2/24, denying the allegations made by the BPC. Next para. The petitioner's counsel submits that the petitioner thereafter approached the court of the civil judge senior division, Kamrup M.
Come
Which was-
commercial court.
Huh?
Civil judge, in your division, come commercial court,
Civil judge senior division,
commercial. court.
commercial court, Kamrup Metro. Under section 9 of the Arbitration and Conciliation Act 1996. Praying for referring the dispute,
No, for, the injunction,
appointment,
for injunction,
will this give me the arbitration?
for injunction, my lord, ad interim injunction. Not to cancel the dealership agreement.
For an interim protection, restraining the BPCL from terminating the agreement, dealership agreement. The commercial court thereafter issued an interim order dated 3/7/24, restraining the BPCL from taking any coercive action against the petition. Question. As the BPCL did not appear before the commercial court on subsequent dates, the commercial court made the interim order absolute by the order dated 7/9/2024. Question. Next para. The BPCL thereafter, the petitioner's counsel submits that the BPCL had quietly gone, had thereafter approached the appellate commercial court. That is the court of the additional
District judge number 2.
additional district judge number 2, Kamrup M.
And before that, my lord, on 15/7/2024, we issued for a letter to the BPCL for appointment of the
Arbitrator. Okay,
That
right.
was
Prior to
second
that, prior to that, huh? Just right. The petitioner's counsel submits that after the interim order was made absolute by the
No,
order dated.
after the interim order dated 3/7, my lord.
After that is 3/7/24.
Yes, yes. Then
This-
immediately
No,
the
no, absolute was 7/9/24.
7/9, before that, my lord.
Before that, okay. So it is before that 7/9/24, huh?
Yes.
Just say, after the interim order dated 3/7/2024 was issued, the petitioner submitted an application under section,
21. Submitted a letter to
submitted a letter dated
15/7/2024
15/7/24 to the BPCL
for
for appointment of an arbitrator
for resolution of the
for resolution of the disputes between the parties in terms of the,
section 21.
huh?
In terms of the section 21.
In terms of section 21 of the Arbitration Act. Pusta. Next. Then thereafter that 7/9 will come, huh? 7/9. Then next. After 7/9, it will be the BPCL thereafter approach the appellate commercial court. That is the court of the additional district judge. Additional district judge Kamrup M. And the appellate commercial court stayed the order dated 7/9/24.
Correct.
White order dated 5/12/24. The petitioner's counsel submits
Then on 6/2,
that the
2000
petitioner was not made aware of the pendency of the appeal filed by the petition by the BPCL before the commercial appellate court. Correct? Or notice was issued to you?
Notice you received, my lord.
Acha, acha. Don't they cut that. cut that
No.
last bit. Yeah. Okay.
On
Then
6/2/2025, my lord,
Ah.
we have filed the section 11(6) application for appointment.
okay, next para. The petitioner thereafter filed an application dated
On 6/12/2024,
on 6/2/25.
6/6/2025.
6/2/25. Before the
Before this honorable court.
what is the commercial?
No, this is for appointment of arbitrator, my lord.
Okay, under 11(6).
11(6).
Filed an application on which date?
The order was passed on 6.
No. Application.
Arbitration petition number 6/25, my lord.
Filed an arbitration petition number
6/26 of.
6 of 2025.
Yeah.
On?
And an order was passed.
Okay. 6 of 2025 for appointment of an arbitrator.
Yes.
In terms of section 11(6) of the Arbitration Act. And white order dated
6/2/2025.
6/2/2025. And arbitrator was
No,
appointed.
the notice was issued.
Notice was issued by this court, by the High Court,
Right.
by the Guwahati High Court. Full stop. When was the arbitrator appointed?
Not appointed.
Not appointed.
You know,
Full stop.
it's pending.
The petitioner's counsel submits that the arbitration application number 6 of 2025 is
Pending for adjudication.
is pending till today in this court. Full stop. Next para. The petitioner had also approached the commercial division bench,
Commercial appellate division bench.
commercial appellate division
Bench.
bench of the Guwahati High Court.
Yes.
On wide.
By 13/2/2025.
No.
Order was passed.
No. What is the
Appeal
case
number
number?
1 of 2020.
Wide appeal number 1 of
2020. That was the
2020.
first appeal, my lord.
Appeal number 1 of 2025. For stay of the order
Challenging the
dated,
order dated
challenging the order dated
5/12.
5/12/2024 passed by the appellate commercial court, Kamrupen.
In IN number.
On the basis of the notification dated,
Note, High Court notification dated.
on the basis of the High Court notification dated, on notification number,
Then.
Annexure 20,
annexure page,
Annexure 20, page 321, the 26th of September 2020.
Yes.
notification number 62. Dated 26/9/2024. Issued by the Registrar General. Full stop. The Commercial Appellate Division Bench thereafter issued an order dated 13/2/2025. Fixing 27/2/2025 for further proceedings,
For further hearing.
for further hearing. And in the meantime, state the interim order dated 5/12/2024 passed by the appellate commercial
Commercial.
court, commercial appellate court. Full stop. On next panel, no, continue. On 27/2/2025, the hearing was held and the commercial appellate division reserved the matter for the case for judgment. Full stop. As there was, no, next panel. Taking advantage of the fact that the interim order passed on 13/2/2025 was only up till 27/2/2025. The BPCL issued the impugned termination order dated
12/4. That pays 332.
12/4/2025, terminating the dealership agreement between the parties. First one. The Commercial Appellate Division of this court thereafter issued order dated 23/4/2025, holding that it did not have the jurisdiction to decide the
The issue.
decision, the decision, huh?
The issue involved.
The issue involved. That is the decision of the appellate, commercial appellate court.
Division. Commercial. Yeah.
The
Commercial appellate court.
commercial appellate court. Right.
Without expressing any opinion on the matter.
Without expressing any opinion on the merits of the petitioner's case. Next paragraph. The petitioner's counsel submits that in terms of the Constitution bench of the Supreme Court in the case of
2024. 2024, 6 SCC 267.
Just show me that.
Paragraph 90.
Nineteen.
19.
Submits that in terms of the judgment of the Constitution bench of the Supreme Court in High Court Bar Association, Allahabad versus State of Uttar Pradesh and others, 2024, 6 SCC 267.
Paragraph 19, the question was formulated, my lord, and it was answered.
But this does not really say anything, not very clear.
Without, if a stay order passed in judicial order, my lord, unless it's vacated, unless it's vacated, my lord, or modified or decided. How could a litigant?
What did let us see the commercial division order. What was the order?
Yes. Not you will find that page 380. The final order, or nothing is asked for, or this interim order?
The interim order.
Interim order. Now she will find 322.
Which at para 19 states as follows. See?
322.
Till the next date of this thing.
Till the next. On 27.
Anyway, right. Okay, that's 19. Okay, you take the 19. Next paragraph. Next paragraph. Due to the judgment and order dated 23 for 2025 passed by the by the Commercial Appellate Division Bench. In Commercial Application Division 1 of 2025. Dismissing the appeal of the petitioner, the petitioner approached the Supreme Court.
Not against this order, my lord. We are not challenging the order of the commercial division.
I know.
It's a
Okay.
absolutely correct
Okay.
order. Then, because we have
So
challenged
you
high court
challenge
order,
right, yes, because of this. I mean, what have I said?
then we again
Therefore,
challenge the high court.
and as
That
the only alternative left to the petitioner was to approach the Supreme Court against the commercial appellate order.
Yes.
Commercial appellate court order
Dated.
dated 5/12/24. The petition approached the Supreme Court vide
Lord, you will find paragraph 34 of our interpretation,
34.
page 19. Page 19. Bottom.
Vide SLP bracket C number 12417 of 2025. However, the Supreme Court declined to interfere with the order dated 5/12/2024 and instead directed the learned Additional District Judge number 2 to hear the misarbitration appeal number 9 of 2024. Expeditious. Where is the order of the Supreme
That
Court?
was till now not uploaded, my lord. This is a difficult. But on
Expeditious.
affidavit, we are saying.
First stop, next paragraph. The petitioner has now come to this court against the termination order dated 12/4/2025. Stating that the said order could not have been passed during the pendency of the
Arbitration proceeding. my lord.
arbitration proceeding before
Because the arbitration.
before
proceeding-
whom? Before whom? There's one is here, one is there.
Yeah, but since the arbitration proceeding has commenced as per section 21, they should not take any decision, my lord.
Who should not take?
Once I issued the notice, my lord, for appointment, then it is commenced as per section 21. And it is
So
also
you mean
pending
if
before
you-
the appellate court, my lord. It was not disposed.
Because of the
appeal was
pendency of the arbitration cases pending before the
Additional district.
additional district judge and this.
As well as,
And that's all. That's the only case.
and this, may I place the judgment of the Supreme Court, my lord, where it says that the 226 is maintainable for termination.
He submits that, what? He also, the next para, the senior counsel for the petitioner submits that
Paragraph 7.
I'm doing all this because next day I will not have to write all this.
Yes, and then it's correct, my lord. It's correct, I need not to submit this. Lord, will take a call.
No, it's not that. It takes a lot of time.
Yes.
Now we are free, that's why.
Yes.
Sometimes we're not free. Yesterday, we sat for quite long.
Good exercise.
We have to.
Paragraph
Yes,
seven.
paragraph.
7. Three exception. 226 against the parliament.
Oh. The petitioner's counsel submits that the present writ petition is, the issue raised by the petitioner can be decided in under Article 226 of the Constitution. Even though there may be an alternative remedy available. In terms of the judgment of the Supreme Court in the case of Harbans Lal Sania and another versus Indian Oil Corporation and others, 2003, 2 SCC 107.
Other judgment also, I'm not burdened this one. This is settled.
Mr. Edeka submits that that the councils for the BPCL are out of station. And as this case was listed on the basis of a mention made this morning, when the councils had already been out of station.
Yesterday they went.
And as the councils had left Guwahati yesterday,
Yes,
the matter may be listed on
Monday or Tuesday.
when?
8 or 9 on a
8 or
TV.
9 again.
My only prayer,
And
my
seven
lord,
lots of
kindly
questions.
consider that this read petition also be to be infructuous. Then
No, there's no. Yeah.
8 or 9.
6th of,
Where is he? Where they going?
he in Arunachal Pradesh.
Then on 8th and 9th?
Again, 8 and 9 also think whether in the Arunachal Pradesh. He informed them. Okay, except 8 and 9, any deadlock. That is why I am requesting for 5th or 6th. Or
Somebody else can hear it. I don't have to be there.
7, my lord.
7th is holiday.
Oh, 7,
sorry.
Panchayat election.
19. 8 and 9.
You see, you have to ask them you talk to them. 8th or 9th.
Everybody is having difficulties, you know.
6th of May, nothing. 6th of May.
It's a difficulty.
He is having difficulty. He is out of station.
You lords already
You
recorded.
see,
My presence is required.
you see,
The important.
Arunachal, maybe better instructions are there, but
Yes.
sometimes they have got to, two of them need not be there.
But
Who is-
two of the council, my lord.
Why both have to be
Ah,
there?
Two of the council.
Two, let me have.
Just talk to them. We've got quite a bit, no? We are,
No. Who should be burdened with work?
no, you see, our work starts after we go out of this point.
Yes, I know, my lord. It's a very difficult. My only problem is, my lord, is answers, my answers. I just expressed this, that if they take over, then that thing, this repetition will be also.
But then,
Remedialist.
but
The
then,
person should not be remedialist.
no, that is a different thing.
My lord.
But on the other hand, there is something wrong with the dispensing unit. Ninth.
Their dispute to be resolved by arbitratorily. I cannot decide now. The rich court also cannot decide. Prima facie lordship.
Okay, ninth.
Till
Whatever.
then,
No, listen.
no, then they are not, they send the person on yesterday, my lord. They will send tomorrow also. So this is not from expecting for a PSU. my lord.
Mr. Godho, implement, nothing is going to.
Nothing, that statement may be recorded, my lord. Nothing has to be happened.
Over telephone.
Yes, that.
No, you see, if there was Supreme Court would have given you protection. If that was the case, Supreme Court would have given you.
No, we cannot challenge termination before the Supreme Court, my lord. We cannot. We cannot challenge. But that undertaking may be recorded, my lord. Please. No, kindly.
No, they have said nothing will happen.
Yes,
I remember.
Okay.
If something happens, then we'll see.
Yes.
What I said? List the matter on 9. On the prayer made by Mr. A. Deka on behalf of Mr. S. Gotakur
For BPC.
for the BBC.
Expression of
You tell S. Gotakur not to do anything.
No, that's sufficient.
Yes.
So you want this? No.
Grateful, my lord, and lordship has taken it. Getting a council due.
At least the facts of the case we know.
Yes.
Only now is the
Is the
issue to be looked at.
Yes.